snow fell cold on a bitter night. John was gone for the morning light. They blame Karen, but it don't sit right. Too many secrets hid from sight. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town. Proctor's story shifts and sways. Cameras vanish, records fade. The Alberts toast while the doubts grow strong. The folks still fight, won't be long. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town. Proctor's story shifts and sways. Cameras vanish, records fade. The Alberts toast while the doubts grow strong. The folks still fight, won't be long. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if anything you might be, and welcome to what will not be the last day in the Karen Read case. I don't believe that we will get a verdict today. I've seen people saying, well, it's going to be an in and out, and it's so obvious that we will get a verdict today. But Jamie, as a seasoned vet on the court watching, do you believe we'll get a verdict today? Interesting take, Jamie. Well, I didn't think about that. Yeah. I shouldn't have asked you a question when you're not at your microphone. Well, am I an amateur? Yeah. Did I want to bring people in? Yeah. And do I feel like a fool right now asking a question to someone who's not here? I'll play it off anyway. Yeah, Shax, I love when Jamie has the hot takes. Hello, or guten Nachmittag, Anna-Katrina. Mary Casey, I will tell you one thing. A lot of people were asking me yesterday what I'm going to do when the Karen Read case is over. I'm going to go do what I've done since I started this channel. I'm going to cover more cases. If I have learned something in my 7th of September, I think is my 3rd year or 4th year, is the jury is always unpredictable, and most of them sadly doesn't understand that they are there to rule on the evidence. They rule on their fifis. Fifis are not what you need in a courtroom, and sadly, way too many cases is, well, he looked bad, he must be bad. So I'm thinking I would keep my hopes down a little bit. We got a new defense motion filed. Good morning, everyone. Good morning. No, me and Jamie is not fighting. She just didn't want to answer my questions. She pled the 5th.
I was just chatting away, and I was like, did you not hear me? I thought you were making fun of me because I said, oh, absolutely not. That's what I said.
Vicky Hat, sorry. You didn't send any links, but if you didn't make a space between a point period and the next letter, Nightbot catches it as a link. That's why it'll say, don't spam links. Nightbot is kind of like my ex-girlfriend, not always reasonable. So give it a chance. And it looks like we're going to go only 7 minutes late. And
Oh my goodness.
No, we need to be heard, unfortunately.
Okay, come over to side.
You need to be heard, unfortunately.
Oh, so he's going to cry and claim those slides they want to put in is all wrong and it's trial by ambush. Lord Bynum, I'm sorry. I do that to people.
No, he can never chase me off.
No, as long as I don't show up at her house, she's fine.
Yeah, stay away from me. I'll be okay.
No, it's they said you have to be here at 8:30. The jury will be here at 8:45, so we are ready to go at 9. And yeah. Ambrosia, you're just gonna have to sit and listen to him talk for an hour and 15 minutes.
All he's gonna do is just play those clips.
Yeah, he's gonna play those clips for an hour and 14 minutes and then 1 minute of Jen screaming, I hit him, I hit him, I hit him.
Yeah. He's gonna tell us how guilty she is because of all the things she said. I mean, they don't look good, but
no, and that's why I still think there is an unreasonable chance, but still there is a chance she will be found guilty in manslaughter. I can't see those clips kicking it up to second degree, but I could see people say, well, she admitted she was drunk. And is it fair? No. Was everyone drunk? Yes. Have you all told me this a million times? Yes. What do I base it on? 3 years of experience. And but John Stad is there today. Look who's not there. Not one McAlbert is in the room today. And by the way, congratulations, Aiden, for having been found not guilty in violating your restriction order yesterday. And Chrissy, who used to watch my channel, but apparently is very anti-Karen Reed, told me that I suck up to Turtle Boy because he pays me money or something, or I earn money.
What?
And I said, you normally seem nice. I think you should go outside and get away from the internet for a couple of days.
Touch grass.
Because one thing I don't do is I don't cover much Turtle Boy.
And getting paid, like all this accusing people of getting paid. Like, come on.
Let me be truthful. Would I be doing this if I didn't get paid? Probably, because I like covering cases. Would I do it as many hours as I do if I didn't make a certain amount of money every now and again? Probably not, because I would have to do something else. Am I a grifter? Everyone on YouTube is a grifter. We always want just one more sub. What don't I do? I don't sit here and say, hey, I have a Venmo, I have a Cash App, I don't sit every 10 minutes and say, hey, could you please, internet is getting expensive in communist Denmark. I need at least $100 in super chats. Within the next hour, all of the stream will end. Come on, could you all just chip in? I don't sit here and say, I only made $40 on a stream. I can't do this. I have a lot of streams where I make $0. And I still do it because I like being a YouTuber. It's fun. You're crazy people, but I love all of you. And again, yes, I am blessed beyond what should have been allowed. It makes me go to Americas and do crazy stuff and get the Rona by kissing Valhalla.
You brought the Rona with you. Stop it. Stop it.
Well, you brought it
just
out
for the
with me.
record, I would like to take this opportunity to point out that I do, in fact, have a Venmo at Valhalla_awaits and a Cash App. Cash App sign Valhalla awaits 3. Just putting it out there. Just putting it out there. Oh, God.
Well,
body
the sequence
aches are what's getting me.
What's getting you?
The body aches. My back is just.
Yeah, I feel like I've been crossed that, but I never tested positive for the Rona, but I think I had it like 2 or 3 times, and every time I just feel like I want to sleep for a week. You'll survive. I'll survive. I don't care.
Yeah.
Yeah.
So
We'll be all right.
but
We'll be
again,
okay.
I love the people who today, because there's a lot of cray-crays going cray-cray on the twat today, and all of it is you're a grifter and you're fat. I tell you this all the time on every stream. I am a fat grifter. It's not like it's news to me. I have mirrors in my house. Again, give me something better. Say I don't speak English or something like that.
Have a valid argument. Like, I love
Well,
when people
I
just start
own-
throwing insults.
I
That's all
own
they
a
got.
mirror. I'm aware that I'm a chubby grifter. I get that. That makes sense.
It's I just love that it's such a great. Did you see that John Petro, whatever his name is? A lot of people telling me I do a great, unbiased, award-winning, worthy.
Shut up. He is such a liar.
I can just confirm that a lot of people has also reached out to me. I won't share the DMs and said, "Hey, you are the greatest YouTuber ever. We don't watch your channel, but you are amazing balls because you are the bestest ever, and your grasp of the English language is amazing. I love you.
English.
I want to have your children, and I owe you $1 million." Everyone wrote that to me. Maybe like 100, 200,000 people wrote that to me yesterday. I can't share the DMs or show them to you because privacy, but that is what people said.
Ooh, shout out to Shizzy for buying me this awesome shirt.
Oh, let's picking it up.
Oh yeah, baby. USA, USA, USA.
Oh my goodness.
Outstanding.
Stop
Outstanding.
it.
Outstanding.
Yeah,
That's
I always
such a Midwest shirt. You know that, right?
I should have brought I got 3 doggos with the red, white, and blue as well.
Oh, you got dogs?
Yeah.
Dogs are way better than cats.
True
He's
that.
all sad.
First and foremost, we like you
Winter.
because you do what you do and how you do it. It's a pleasure. Anna Katrine, thank you so much. It means a lot. No, I just love that argument that, oh, you're a grifter. Well, YouTube is about trying to get an audience. And I have been quite successful over the last year. Yeah. Do I have a lot of daily viewers? No, but they come in for special streams and stuff like that. I'm doing great. Baker probably never told the waiter in Spanish restaurant in Spain, "I don't want the English menu. I don't speak English. I'm American," in his best English. Yeah, I should do that. I'm going to, Serenative, I'm going to go to Germany, make a meetup, and everyone will have to be there, and I'll say, ich weiß nicht, aber du, weißt du, wie groß ich bin? Weißt du, ich bin eine große YouTuber. Ich bin ein Influencer. Ich brauche keine Menü in Deutsch. Ich spreche nur English. I think that was kind of correct.
Like 2 people might know. That's nobody.
Well, Anna
I'm
Katrine and
Berliner.
Serenative will know. Well, and all the Dutch people will know as well.
Hi, Mo.
Hey, Mo.
Hello. I just walked in and I'm like, do what now?
German.
Poland? Why?
I was like,
Too
wait
early
a
for
minute,
that.
what's going on here? Did we all decide to speak a different language today?
I hope not. My Spanish is terrible.
I mean, I
Yeah.
barely speak English, so.
Soy habla
Muy mal.
español.
Muy mal.
Fair point. Mine is about the same.
You don't sound nearly aggressive enough in German.
Yeah, what's up with that? Why do Germans always sound like
mir
this?
keine Menü. Ich brauche nur Schnitzel
Goodness.
und Sauerkraut.
That's better. Germans always sound like
angry.
they're ready to fight.
Yeah, it doesn't sound like a very like friendly language.
But that's
Again,
because you
if you're
only hear
just
it in
hearing
movies.
it.
No, but German is a more. Du bist mein kleiner Schmetterling. Oh, du bist so schön. Ich mag dich sehr. See? Sounds good. You're my little
No, it
butterfly. You're
sounds
so
sneaky.
lovely.
It sounds like you're about to sneak up on her and hit her with a bat. That's what it sounds like.
I just can't, I want to say like, no, I'm really blonde under here. I'm blonde. Don't be mad.
My 2 people German audience just went away.
Island
Sorry.
says, I just woke up and Baker's already upset. How? That's just
Because
his
people
natural
call me
state.
fat online.
Oh no, we do
can't
not
get
fat
a-
shame the baker. I'm
Well,
there.
No one fat shames him more than me, so.
Oh,
You can get around with English in Germany just fine, but it's the entitlement of that lady in the story. Yeah, it's the, who I have to speak. And yeah.
Wait,
Que
Well, I mean,
todos
there's a-
tanga un gran dia gente increíble.
I will say, if I were going to go to, Germany, I would try to use some, Rosetta Stone, or try to at least pretend that.
No, please
Because,
don't do that. There's nothing we hate more than tourists coming over saying, hey, yeah, hot dog. We'll just look at you and say,
Baker,
do you want a hot dog?
I'll have
Yeah.
you know that our local Mexican restaurant has found it very, very helpful that I start saying everything in English, except at the end I say gracias.
I do the...
And they appreciate it.
They really like it when you say tortilla instead of tortilla, because they're just you guys are doing a fantastic job. Love watching this on the best. You're the best crew. Love you all. Yeah, it's gonna be. I'm not gonna be live. I think we all feel this. It'll be nice when we don't have to sit here every day together again for another 31 days.
As much as I love y'all, I am ready to
Yeah.
sleep
Yes.
past 8 a.m.
Yeah.
I'm ready.
Oh, God.
Thank you, Katie. Baker, am I covering the Idaho 4 case? I'm not sure. I've been looking a little bit at it. I have talked to Julio, who is really good on it. German is really good for harder music. Yeah, some Rammstein.
Du hast.
Now make ein Sentence with Schwanz und Kuhnen. Ich habe eine...
What were those words?
Ich habe eine... I shouldn't say that.
That's the way they say their swans, trucks. You know how we used to have swans trucks with the frozen
with the
food?
French toast sticks. Yeah.
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 Those things are fire.
Es
Or a curse
Du kannst
word.
sagen, es ist ein bisschen wie eine French Toast.
Vienna sausage.
Bisschen
and
lang
French
und
toast.
dünn.
Okay.
Okay.
Thank you, Bry Bear, for being a member for 8 months. What's Brennan playing at this morning? He wanted a sidebar. They went to sidebar. They put OnlyFans
sidebar
on, kind
already?
of like the jury was coming in, and nothing else has happened. So that early start haven't happened. And Lynn Dalton, they have not even proven to me that she was drunk. I'm firmly not guilty. Listening to the other side last night gave me some fear. Lawyers, not anti-reads. Gods that be, please send freedom to Karen. I have tried to temper everyone's expectations because juries don't do what a jury is supposed to do. Listen to facts and rule on law. Juries rule on, hey, my tum-tum says this. And like I just put on Twitter 10 minutes ago, that in my 14 years of being a juror in Denmark, we are always told it's important to listen to the facts. This is what we rule on. But again, we have a judge in the room with us. So when we get in there and we start talking about, well, I don't feel like, well, we're not here to feel. We are here to evaluate evidence. How do you say grifter in Danish? We don't have a real word for it.
Baker.
Well, baker in Danish would be bager. So it's a little different.
Bear?
Bager.
That's what I said.
No, you said bear. Bager.
Saying the
B-A-G-E-R.
same thing. B-A-G-E-R?
Beger. Bager.
Bager.
Or if you want to do it a little country, it's Bauer. Kind of like a farmer in German. Come on, you three. We have proved you love each other. You were sitting together on the couch. Well,
I don't think that's a question.
I think
We
it's
do,
the
in fact,
Hank
love each
we
other.
all won't miss,
Yeah.
the law enforcement, and I saw.
Lar. The
hey,
lar
I'm going to
enforcement.
whoop this channel. Guy's running down the beach, sees a girl without limbs crying. She says she'd never been hugged before. He hugs her. Same thing next day, but she said she's never been kissed. He kissed her. The day after, she says she's never been docked. So he picks her up, tosses her in the ocean, and runs off.
Oh gosh.
Hey, Rosalind Duke.
I was waiting for and then he pile drived her on a meat bat, but it took a different approach. Thank you, Brennan.
It did.
That's better.
This is it was a surprise, but one of the good ones.
Hey, Iris.
Oh, Iris is out of bed.
Ooh,
Did you
hey.
get sick as well in Tennessee?
Yeah, Rosalind, I
think I've
hope
seen
you're
her
okay, and Mr. Duke.
Yeah. Well, they didn't kiss Valhalla like the rest of us.
That's true.
It was with Valkyrie's consent.
It was
Yeah.
just a little hello kiss on the mouth. That's all it was.
We were trying to be intercontinental.
A kiss on the cheek can be quite sentimental, but diamonds are the girl's best friends. I like that movie. Thank you so much, Kelly, for supporting with 3 corner kisses over on Buy Me a Coffee or Buy Me a Corner Kiss. This morning I watched CLR Bruce Rivers, who never talks about Karen Reed. Usually at the 43:09 mark, I had to watching Bev talk under her hand to herself. I missed that before.
I saw that.
I've seen it
yeah.
on the twat, but again,
Who knows what she's saying
we don't know.
or who she's talking to?
Yes, they called a sidebar just as they came. Brennan said, "Unfortunate, we need to have a sidebar," and that's it. Corner kisses, yes, that's instead of buy me a coffee, you buy me a corner kiss. It's from the Cara Rentala case, another injustice done in Massachusetts, in my opinion, where a guy. Well, it's a famous case because it was the first lesbian married couple where the spouse killed the other one, allegedly. But the victim had a boyfriend at the fire station where she worked, and he was only allowed to kiss her on the corner of the mouth. It stuck around because we did a lot of speculating about how does a corner kiss look. None of us was quite sure. This is my rendition.
I forgot about that.
My favorite.
I forgot about that.
I own that original copy.
You should
Yeah.
put that on a T-shirt. I think.
I want
Jamie
to
has
frame
a-
it. I need to go get a frame for it.
I colored it for Jamie.
Last year at Dollywood, you brought it. I think, right?
No, I sent it to her. So
No, you brought a bunch of them last year at Dollywood, though.
yeah. Well, I did. Yeah, I think I bought some. Yeah.
Yeah, you.
I
brought a
had the
bunch of-
Rona, and my husband did too well. I smoke, and he doesn't. He had it for over a week. I had it for 3 days because I took hospice. Yeah. Again, I don't see a reason to go get a test because hey, I'm single. I'm staying away from the grandbaby. I'm just gonna sleep when I'm not on screen. Sidebar is likely one or two things: Bowden issues, or since Hank called it. Change. They had that final thing. The last slides they wanted to put in could be that.
He's probably talking about how he's not. He doesn't want to deny their Bowden defense, but
Yeah, they should not be allowed to have a closing argument.
Yeah, I mean, he doesn't. He wants a robust defense, but also, can we stop the defense from doing a closing?
I would never dream of taking away the defendant's right to defend herself. However, we can't
Yeah,
allow her to
Brennan.
defend herself.
Jamie, can you
Yvonne-
read this?
What? On the
Can
screen?
you read this?
No.
Yeah.
Pimpernilla, Ik, Heb, Vulpin, Vin, Hez, Rizu, Spanded.
Ich hab Vulpin, Wind has rise. I lost the last word.
Oh, sorry.
It's okay.
That's not German. That's Dutch. Just so
What
you
am I saying?
don't have to yell it.
It's not, yeah, it's not as angry.
Valhalla, when you were doing that, all I got was the German chick from, oh gosh, what is it? Austin Powers.
Nice. Nice.
Congratulations, Spire. And I love the closing argument. I don't know what you're talking about. I just found some random video online that I wanted to share with you. I was just worried Brandon didn't comment on my tie knot. I really tried to get it in focus as much as possible. And it's not a balloon knot.
The one collar up really did it for me.
Yeah. Bukaki is in the courthouse.
Oh, gross.
Interesting.
Yeah.
Jesus. Well, I guess everybody.
I'm just
needs something to,
surprised you can write that name. Normally, you can't write it on YouTube.
Yeah, I'm actually kind of shocked too, because normally you have to.
Harry is he can teach you how to speak German.
Okay, if I learn from Harry, would everyone be upset if I attempted to learn, and try when I go over? Or would you rather me just not butcher your native language? Because Baker's telling me don't even try.
No.
Well-
I think we should support Mo in her decision to try to learn German. I think this is a great idea.
Harry, can you do a stream with Mo and teach her to speak some basic Germans?
We've
Swear words
already
first. Swear words first.
I just suddenly realized I can't pronounce English correctly. This might be signing myself up for something I'm not good at anyway.
Right?
Yeah, Yuri Bukaknik, or Bukaki as Jen McCabe calls it. See?
There you go.
Hey, sounds good. And then people can learn American from me.
They all know American. It's called.
I
English.
know.
They all speak
Look,
English.
they'll learn how to add S's and the to things they don't need to fit in the Midwest.
The oldies.
You are unmuted.
The Aldi's. Put the in front of everything.
Yeah, do a stream with Harry where you discuss how you got from Aldi to the oldies.
Well, we made it better. That's what happened.
Oh,
Yeah, I need my mouse too.
I need my mouse too.
Harry doesn't sound angry.
Many say German is easy because the letter are pronounced the
All right,
same.
so why don't I see counsel over here at side
Well,
by side?
Another side.
German is the root of the language is kind of like English, so it's not that hard to learn. And the only reason that a lot of Germans don't speak that much English is because it's a big country. It's the biggest country in Europe, so it's the same with French. They don't speak English, but that's because they're arrogant.
It's like the size of Wisconsin.
They did
89
what to
million, I
Aldi?
think they are.
Okay, look, in the Midwest, it is a thing to call it the Aldi's. Now, I understand from Baker, and it hurts his soul, that it's pronounced Aldi, and there is no the or an S at the end. But if you're in the Midwest, it becomes the Aldi's, okay? So in the continent, y'all can have it your way, but in America, it's the Aldi's. I'm sorry.
Speaking of which, the Aldi's has a new wine section that's pretty awesome.
Ooh.
They actually have some good stuff. Yeah, they're alcohol section.
Look, it's like when we let McDonald's start going to other countries and they made it their own.
Oh, Christ.
We call it McDonald's. We don't go around and say the McDonald's.
The McDonald's.
We wouldn't get mad at you if you did.
No.
We call it the Golden Arches. Do you call it the Golden Arches?
Well, we call it the golden seagull.
The golden
Okay,
seagull.
That's weird.
How do you get an or how do you get this?
Because it looks like a bird. Like,
Have you never drawn a seagull?
yeah, like drawn a bird.
Looks like a Bob Ross painting. I get it.
Okay, I
Happy little
all
seagulls.
right.
Okay.
Happy little seagulls.
Happy little seagull.
You know, I
How
will
do
say
you,
I
as-
like Peg's shirt.
How do you sit? Okay, first of all, boob windows do not belong on 7-year-old women. Second of all,
Well, but it's more of a throat clavicle window. I mean, it's. I'm
Better
just saying.
chest. Yeah.
how do you sit through all of this testimony for
Seagulls.
That makes more sense. Thank you, Baker.
There you go.
Why does the person have a beak down there?
But why?
It's a nose.
What is that person doing?
Is it
Running
jumping?
away from the birds. Haven't you seen
Where's
the
his
movie?
other leg?
Why is he scrunched up like that?
Because he's running, Jamie.
That's not people run.
Look like a baby.
Everyone's a critic now.
Why does he have angry lines above his head and all around?
It wasn't angry. He was scared for the birds. Never seen that movie?
Who's scared of seagulls?
Have you seen? It's the rats of the sky. Well, that's pigeons. But have you seen them? They fly in and eat your French fries at the promenade.
And that's
On Friday we do arms because if you want your nuts flapping on your chin while you're at the budget inn, your arms better be effing swole.
outstanding.
I feel like
Now,
Brennan can get away with more when he just puts it in that voice.
Did we watch back and figure out if it was the defense first and then the state?
It's defense first. I've seen a few people talk about it.
I don't know if I like that because I feel like then the state gets an entire, hour and 15 minutes to lie. But the state would usually have the, last say anyway.
Last say anyway. Yeah.
We call it macas. Macas
Oh.
sounds like something a kid makes in a diaper.
I thought you guys said Mackers. I didn't realize it was an AS. Maccas.
Who is the
Honestly, I
older
don't know.
man by Mr. Reed? The older man. I don't know who the guy. He doesn't seem like he knows him, but it's Mr.
Oh my
Reed.
God, we
Miss
found
Reed.
Bartle
I
from Bartles
think
and James.
is this. Does he have a sister or a sister-in-law? I can't remember. Then I have Esty and Commonwealth appellant lawyer, Mr. O'Keefe, Miss O'Keefe, that weirdo. What's her name? Don't know. I think this is the guy who pushed Karen.
Yeah.
I think this is Paulo Ball's wife. Paulo Ball.
Is that Aaron?
Isn't that Aaron with the black hair?
I don't know. I can't see her.
I have facial blindness, so I can't tell. Paulo Balls, and I think this is a lawyer as well. Sue from Boston. Don't know. The weirdo John Petro something. Don't know. And this is a human thumb.
That is a
He's got a
newly
distinct shape, don't he?
that is a newly shaved head. Also, sir, you might want to put some sunblock on that this weekend if you're going out to the Cape, because that's going to
But he's-
burn and peel.
I bet he speaks walrus.
Doesn't have a sister. I think it's Kelly Reed's mom, maybe. Could be. Just said they restrict press until 10 as they will bring in more stools and standing room later. Thank you.
Oh,
Turtle Boy didn't make the cut. He hasn't made the cut more than 3 days or something. Funny enough, how it's never him who gets drawn in the lottery, but Grant gets drawn every week.
The completely
Karen does have a
random
sister,
lottery
Leslie.
system.
He looks like Spencer Tracy.
Who's Spencer Tracy?
That's that old detective. They made a really bad movie with.
That's Dick Tracy.
Oh, that's Dick Tracy.
Yeah,
Spencer
Tracy,
Tracy, I believe, was an old movie star.
Born 1900, died in 1967.
Well, that's why I don't know him, because I'm 27 years old.
It was way before your time, Baker.
I didn't.
Yeah,
realize,
I think Karen's sister or whatever it is has been in my chat as well.
Oh, cool.
Listen, Turtle.
Listen, Turtle.
Oh, and yes, a few more people has come in. If you didn't watch it yesterday, fake victims RO case against Aiden Carney was resolved yesterday. He was found not guilty. Remember first trial when the O'Keefe family invited Lindsay to the trial to participate and show support, as they said. And because she has a restraining order, which she brought to her with court, because you always wear your restraining order with you. Aiden left the courtroom, stood on the other side after being told by a police officer, if you just go on the other side, it'll be fine. And then they claimed he wasn't 100 feet away, so he was in violation. She also claimed either he or someone on behest of him had kicked her tail light in or something stupid like that. But he was found not guilty.
Not another tail light.
Yes. And Paulo Balls was testifying in court yesterday. He didn't know Lindsay Catani. He didn't invite her. It was Kate Peters through her that she was invited. Remember, Kate Peters has a pending case for breaking her restraining order against Aiden Carney by acting through immediates. So we now have Paulo Balls who can be called to testify and say, yes, we invited her because Kate Peters asked us to.
That's illegal. You can't weaponize a restraining order, y'all.
Well, she had it in her hands when she entered the court. That's a little weird.
Isn't it? Not the brightest
tail
bulb
lights
in that box.
I never want to talk or hear about taillights ever again. Intermediaries, not intermediates. I'm sorry, Marissa. Someone has the Rona and is a little testy today. And it's not me, because I am always a bundle of sunshine.
Bundle of sticks.
Surprise, Mike.
Did we miss a hot mic moment with Brennan or Lally, or was it just me? I heard nothing else than we need. Sadly, we need a sidebar. That's all we heard. No, they called a sidebar, went out, went back in, called them back to sidebar. Yeah, she literally held out the restraining order like a moron when she came into court.
Yeah, she's not bright.
It's not like a talisman. You don't go around like this.
Well, she claims she didn't know he was there.
Yeah.
Bullshit.
That's the whole thing. I didn't know he was
Is she a new hire?
Yeah.
You can only go to a location you know the RO accused will be and then cry wolf. That's exactly what the argument was from Bradel yesterday. Yeah. She knew he was there and she said, no, I don't know. So, and
he said
actually
he publicly announced it. So
yeah. And again, one of the arguments yesterday was that she did it to Frank a lot.
Well, they had that video of where she drove to where his car was at and sat in it and wouldn't leave his car.
My bad.
No,
the awesome part about using a restraining order as a weapon repeatedly throughout your life is eventually people figure it out. Karma.
Well, yeah, because that guy started videoing her, and thank God he did, because they got that on camera. And she was claiming, like, no, he drove to me and he was threatening me, but that just part wasn't on camera. Okay. It's always the case, too.
With that? No.
Weird.
You are
You
unmuted.
have to be quiet.
Do you agree with that? No, that's complete garbage.
Jurors on their way.
No, we need to be heard.
You
on
agree with?
Okay, come over to
Do you
side.
agree with that? No, something garbage. What?
Yeah.
You are unmuted.
I don't know if it's they just got to looking at the things they were supposed to look at yesterday or whatever, but that's what apparently was said. Thank you, Stephen. Karen Reed has a sister named Anne Reed. There's limited information about her, and she has not been prominently featured in the cover of Karen Reed's case, leading to speculation of their relationship. Oh, I don't speculate. She could be somewhere else. I agree with that. It's just different when the person comes into a room holding the paper like a weapon and then tells other people she didn't have it with her and showed the police later. Yeah, she's a little her. But I think what they potentially could be talking about was, remember yesterday Bev said, I hope you can come to an agreement on this, the slides in the PowerPoint presentation from Dr. Wolf, I believe it was, maybe Rensler. I'm not 100% sure.
Rensler.
Yeah, I'm not. I think it was the Dr. Wolf they were arguing, but I'm not sure. No, it was Rensler because they said we took out all the parts they said. So maybe it's what he says. Do you agree on this? No. But again, let's start early.
Said that it was not coming in because of the objection, and the evidence was closed. But I could be wrong.
She did. That's what I heard too. Is that
but then they said if you can agree on that, send me something by tonight. So whatever it was. Guy walking down the street, Karen stops him and asks, how many times you worn those shoes, guys? Says, why? Karen, they look brand new. Guy says, a recent purchase, but not fresh out of the box. Like your fingers. Yep. It's going to be one of those days, Brandon. Thank you. It's because I don't have any beer in my house and I'm sick, so we can't do the Friday beer. That's why he's pestering me. I didn't tell him anything.
You're not doing the Friday beer? You're not doing the Friday beer?
I have no beer in my house and I can't go shopping because I'm sick.
You don't have a single beer in your house?
No. I just spent a week in America and I've been sick ever since.
I am genuinely disgusted right now.
Well, I have some of the drinks because I didn't know what booze was. Actually, I have a soda that I can drink, so there we go.
I'm going to Snapchat someone and ask if they can bring me a six-pack.
Ooh,
not that I'm going to drink a six-pack. Well, bring me one beer or else Brennan is going to, oh, you have a six-pack. Let's empty that.
Baker's got Snapchat, y'all. Giggity.
That's so weird.
It's his Insta that's really hilarious.
Yeah, I don't go enough on my Insta.
We don't have an Insta.
Anima. I'll take things a wuss would say for 500, Alex. Outstanding. Outstanding.
A 12-year-old can't bring a beer Snapchat. Well, I think she's 33 or something. But,
that's what I was thinking for
Bailey's. Both.
Frozen pizza. Always good.
Cook it first.
Well, yeah. Mr. Mo, I was feeling like such poo yesterday that after we got done, I basically walked down and said, "Could you throw in this frozen pizza for me?" And by the time came up with my slices, he said I was already dead asleep, but apparently took a slice, ate a little bit, and then rolled over.
Nice. Sleep eating. That's what I hope to achieve someday. Oh, man, my back
I
hurts.
swear, sir, officer, I didn't know she was underage. She said she was 33. Yeah.
But she had a Snapchat. Oh.
Yeah, we were Snapchatting a lot. So, and she did like Kat. She Snapchat me in the shower.
Yeah, who does that? That's a level of togetherness that doesn't need.
I'd do it.
Snapchat was how Tim Swoop's kids were made. Oh, rolling over in bed and.
Oh, fair point.
Yeah, well, that's par for the course, sir.
Also,
That's
par for
bad.
the course, saying we're going to start early, having the jurors have to be here at 8:45.
We're going to start at 9 o'clock and get right into argument, Mr. Brennan.
Okay, you know the first thing the jury's going to say when they go in? Look, we're not coming in Monday, so we're going to figure this out tonight.
I really want them to have it by tomorrow, Mr. Brennan. One of the best pizza spots in the U.S. Huge slices. I takes one insomnia med. If I didn't crash, I would eat a half of a 24-inch pie. I don't know what 24
Uno's?
inches.
One of the best pizza places in the U.S., Uno's? Is that what you're talking about?
No, it's called Joe's. It said
don't
it
think
right
that's-
in the text.
I don't think that's one of the best places for pizza in the U.S. It's no Uno's.
Well, I need somewhere where it'll delete my peen pics. Or I think it'll delete my
Baker's
peen pics.
afraid to use Signal now in case he goes to Massachusetts for any reason.
Did we discuss the denied alternate selection motion? We haven't had anything on screen other than 2 times they've been called to sidebar. Oh, now something might happen. No, I can eat a pizza without any medications too. I like playing Uno if it's do you know
That's
the
the same
version with all the crazy cards? That's the funny one. We always play that at family gatherings.
I love Uno.
You guys sticking around to 5:30 just in case. Baker, you're 1 hour ahead, so that's 11:30, right? It's gonna be 10:30 your time, 11:30 my time. I have a stream I have to be on at 5 p.m. I still haven't gotten the link, so but we discussed 5 p.m. So, but I have said if we are on Verdict Watch, things might change.
Giordano's is also good, MG.
I don't know what the difference is in the different styles. In Denmark, you have pizza and you have deep pan pizza.
So New York has thin crust pizza.
So it's
The
pizza.
crispy, flaky, delicious pizza. Chicago
pizza.
has deep dish pizza, which I personally am not a fan of. I've only had like one slice of deep dish that was good ever.
Mhm.
It's just too much. It's like a casserole of tomato sauce and cheese. There's no reason for it. It's dumb.
I like Detroit style pizza if you're going to get the thick crust with.
God bless it. There's no Detroit style. They just cut it into squares. That's what Detroit style pizza is. They just cut
Fine.
it in squares.
Look, as a carbaholic, I'm going to tell you the thicker the crust, the closer to God.
Thick thighs save lives.
Thick crust saves, well, me from being hangry.
If you get the deep dish in Denmark, you don't get you get the same amount of sauce and filling and stuff like that. You just have a deeper crust on it.
Like a pan.
Chicago's is different. They put like the cheese on first and then tomato sauce on top. It's kind of like a
What? No. Oh, the
Chicago
deep dish stuff?
deep dish.
Deep dish. My bad.
It's kind of like a
sauce, all saucy.
There
yeah,
have
it's
been
like
no
soup in a crust.
It's weird.
Yeah, there's been no rulings today in court. We don't know if it's online. I can see if the girls have said something in our room. Yeah, she denied it. The right to now comes to defendant Karen Reed by and through underside counsel. The right, the selection and seating of jurors, including alternates, is integral to safeguarding a defendant's constitutional right to due process and the right to trial by jury. And ambiguity in the alternate jury selection process would undermine the integrity of the entire trial. Accordingly, the defendant respectfully request that this court issue an order setting forth the method by which the alternate jurors will be identified. The defendant further moves that the honorable court allow the defendant to have input prior to the selection of the foreperson. I can understand why they denied the last one, but the first part I don't understand. But it's denied. But the jury, the defense has nothing to argue about with the foreperson. That's clearly only a judge's ruling. And I know, well, Bev can put someone, yeah, but them's the ropes, man. Yeah, of course she's trying to cheat again.
Who's cheating?
What should Marissa do? Is she mouthing off again?
I think that they were the chat was trying to tell you that the new motion for the thing was in the Discord.
Well, Marissa and I have now been together for more than a year, so I treat her like I treat all my other side wifes. I don't listen to them.
Also, isn't the foreperson picked by the jury themselves? Not
in the. She did that last year, where she said the one in seat number 1 is always the foreperson, and she should do like they did in the Turk case. They did the spinny spin, and then they pulled out the numbers and said,
"Yeah."
But she's not going to do that. Jim is magically going to find that all the ones who looks most pro Karen Reed is the ones that gets off. They proposed a procedure that each numbered ball be shown individually and then placed one by one into a wooden drum with the process visible to the court counsel and Ms. Reed. That the drawing of alternates from the drum be conducted in open court on the record and in the presence of the court counsel and Ms. Reed. That the number on each ball selected by clearly announced shown to all parties and then placed on a designated stand or display area in full view of the court counsel and Ms. Reed. That optimally Ms. Reed herself is be permitted to draw the alternate juror balls from the drum as a further safeguard of neutrality and to reinforce confidence in the fairness of the process. This procedure would ensure that the selection process is fair, reviewable, and consistent with the defendant's constitutional right. So she denied that.
Yeah, I doubt she would let that go through.
No.
Never seen that before.
Thank you, Marissa.
Who said? Somebody in chat said that Little Caesars has Detroit-style pizza and it's not square, and they are full of it. Google, quick little Google, Little Caesars Detroit-style pizza. It's all square, chat. It's all square. All the squares. They're like little rectangles.
They have round.
Forget about the Karen Reed case. The real fireworks is going to happen when we start talking pizza.
Slidey.
Oh, I want pizza.
Slidey, it kind of has. It. They came in. Hank said something. Do you agree on that? To Lally, and then they asked for a sidebar. Then they went out, came back in, and put the camera up. So I thought, oh, it's going to be now the jury's coming in, and they then Bev called them to another sidebar. So nothing has happened as we knew it would. That's why I said when she said 8:45 yesterday, I said I'm not going to do a 10-minute intro because we're not going to get started. It's a 5-minute recess. I haven't heard them say recess.
It's because we've been arguing about silliness.
I'm sorry, Aaron, but
well, we also wanted to get it started because she talk to what's her Randy, not Randy, the bald guy Jim. Didn't she talk to him about they could possibly stay until 7 p.m. tonight?
No, she said 5:30. You
Not a
miss
thing.
absolutely nothing.
Not a
Do
thing.
you say you were going to leave the feed up during deliberations? I didn't say that. I normally do. If I think that there's a reasonable expectation that a verdict will come in, I do verdict watch. I don't believe we'll have a verdict today because, first of all, what the F is going on? Second of all, I think it'll be like the last time. I think they used 14 hours the last time, 2.5 days. But I've been looking at another case I really wanted to follow about a coroner in South Carolina, I believe she is, who unalived her husband with the help of another guy. I might go back and we can watch that while we.
I watched 2 like shorts from that trial. That seems like it's intense. I watched the daughter testify and the guy that was there at the time, like just little clips. I don't know if I would like to watch that trial, if I'm being perfectly honest. Lots of crying, lots of people crying.
Well, it'll remind me of the Smex.
Oh my God.
Edgar, we said we weren't going to talk about that again. We didn't understand that. Water under the bridge, man.
Yeah, the ex-lover testified yesterday. He was fun. And I don't know why you tagged me in something I already read. Yes, but okay. I thought it was going to be today, but not as hopeful. Everyone always believed this is an open and shut case. It'll be over in 5 minutes because we already know what we're going to vote. The problem is the jury is going to go in there. Half of them are saying, oh my God, I need a cigarette. Then they're going to go out and then they come back. And then there's always that woman when they say, did you all have a pee break? Yeah. Okay, let's get to it. Let's do a straw vote. Becky, what do you want?
Damn
I
it,
could
Becky.
use a tinkle. Becky, we just took half an hour tinkle break. Yeah, but I couldn't tinkle at that time. Then Becky's coming back. Then John is sitting over in the corner. What's wrong? He said, it's been an hour since I had my last smoke. Can we grab a smoke? And 1.5 hours in, they'll probably get to do the first straw vote, and it's going to be split all over the place. And then they're getting into arguing about how important the video clips are because she said she was drunk. And yeah. Can we do a... No.
Bad.
No,
let's
no.
go.
Bad, let's go. Boo, let's go. I have had my 1 a year baby unaliving cases. And I don't want to do baby Smex cases.
No.
I've had 2 in real life. Well, one of them was 14 years old, so it wasn't really a baby, but I had 2 of those, and
all persons have any business before the honorable
Thank God.
stick with you.
Oh, thank Jesus.
Draw near, give your attendance, be shown.
Only been here an hour, Bev.
Massachusetts. Court is now open. You may be seated.
We're going to have to listen to you do instructions for 2 hours.
Yeah.
Good morning, Jervis.
Why it's so low?
I have started far too many mornings by saying to you folks, I apologize for the inconvenience, having you wait around so long. I appreciate your patience.
No, I didn't block that one from my memory.
But I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers.
Shut
the
up.
witnesses,
Get to it.
that
She's doing what I hate at meetings. Hey, everyone. I'm so glad you came. Mom, you don't have to be glad because I'm kind of forced to be here. You pay my salary. I just want to say, to begin with, well, 40 of you showed up. We invited 50. The last 10, it's just annoying that they didn't show up. I really wish those people could show up, and I feel like it's shut up. Show me the bad PowerPoint. Let go rambling for an hour, and then we can get out of here.
everything. So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And
If you had just shut up, not talked about anything, just said, "Good morning, jurors, we are ready for closing arguments." First, we would have gone. And two, now the jury isn't sitting there thinking, so they're not important? Are they important? Are they the most important? You're
Yeah, the
such a
jury's like, I could have slept longer.
Yeah.
we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing arguments. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is, you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long
I'm
trial.
going to enhance the audio.
Your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, the constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof, right? The burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments.
That was actually a good instruction, and it sounded fair. I like that instruction. Bev strikes me as the kind of person who never has more than one tab open at a time. A reasonable person, that is.
So she's not going to stop them? That's good.
Well, during the 1 hour and 15 minutes, I think, was the implementation.
Yeah. But I mean, like, remember last year she cut Lally off. Like, you're
Yeah.
done.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system.
Yes, let's try and observe AJ, and then I'll make a poll. I already have one poll up saying, what would you vote right now? I'm going to end that so we can get back to it and listen to it in brutality without too many cats. And 93 would said not guilty, 3% guilty, and 3% guilty in manslaughter. 197 votes. Try to be objective. I know most of you, 93%, thinks that he's going to be the bee's knees. Try and be objective, and we'll rate him. Last year, I think I gave him a 7.5, which would be like a C plus maybe. Try and be objective. Let's see how we rate his closing arguments. Because I didn't think he hit the ball all the way off the court last year.
That has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason. an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
Two of the hardest working set of lungs on the planet right there.
Apparently, this is what the sidebar was about, showing this footage. Thrust.
This part
Thrust.
isn't very.
Thrust.
Why are we
Thrust.
focusing
Sparring.
on this?
Practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor in his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look.
As part of the Bowden, they could.
Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You come in here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scorti-Bello's words. Question: you did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer: no, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scorti-Bello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scorti-Bello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rentschler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess?
He lied.
He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffin's data, Ian Whiffin. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffin himself conceded that he has reasonable doubts about the accuracy of John's location data. Remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffin told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. La Posada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth La Posada, Judson Welcher, Andrew Rinchler all agreed Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. La Posada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scorti-Bello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants. No consent searches, no photographs of the house interior. They didn't treat the house as a crime scene. And shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass bitch. She's got a leaky balloon knot, leaks poo, zero chance she skates. She's fucked. And up to this point, Michael Proctor had done zero investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias, bias in this case. Fired.
Good.
This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those Solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely
25 minutes left.
devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash. Didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? He wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth hasn't presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty, because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage. I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John.
1 hour.
5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins, Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history, a dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabe's. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that read, Hoslong to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video. It's not on audio. It's not in a single police report. It's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video. Multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes
About
inside
10 minutes.
to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moments that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled that how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop. And all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory.
Time's up.
Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory.
Time's up.
What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what
Brennan
that
had
means.
96
In her
and
words,
Jessica
my
Thomas
entire
98.
career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test? Or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining it about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress up in John O'Keefe's clothes,
115, he's
identical
overtime.
clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness, but to you. And asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. Dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth.
It's pretty good for court TV.
And this is what you
It's
get.
the same as last time.
An investigation that's riddled with
No,
errors and
86%,
omissions
I
and a
believe,
rush to
last time.
judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed, not just because you can,
120.
because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins.
Nope, 115.
Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty. Thank you.
Starting a poll. Try objectively looking at it. I thought he started good, kind of went, yeah. I can't give him an A for this because what I want is put the charges up and say, this is why you can't find her guilty. It demands this. I would even say even though he went longer, he went too long, he became a little droning, and he didn't get me there. He was edging a lot, but there was no completion.
I wish
because
go ahead. Sorry.
Yeah, I missed that part where he said, charge one, they never proved any of this. Charge two, they never proved any of that. And that spiel about the community needs to no, stop with the emotions of the community. That's I didn't like that. And because I didn't want to break it, I have a few things to go through. Baker blocked me from describing what I would do to a porterhouse right now. This is against the Copenhagen Convention. I demand reparations. Greg says, something the stream doesn't show is Jackson has a reasonable doubt graphic on the screen and it keeps adding one by one. And I think that's a good way to do it. But he should have, again, put the charges up and why this reasonable doubt applies. Then we have Burgess Hare Island. My peoples. Hey, Burgess. Please mention Dr. Russell AJ and her explanation. I don't think he went all the way into that. Thank you for 16 months, Sebastian. I have a paper bag and some fries on this plane, AJ. Do you think you could help me put the goddamn fries in the bag and land the effing plane? That was 25 minutes ago. I agree. He got a little bit. I didn't like the ending. I got news for you, Sims. The jury doesn't want to get dunked by AJ. This waterboarding is sufficient. They want a pizza or two and then go home. Yeah, they want it in their hands now. I would say high C, low B is where I'm at.
I think that's fair. I think that there's going to be a difference because I think that for the stuff that's important, like you and Baker and I are really kind of agreed on the let's leave the third party culprit kind of stuff out of there. And can we all just agree that that practice fighting comment was about the dumbest thing I've ever heard, other than Randy's not a dummy this trial?
Randy's no dummy.
No, but he's happy. He spread his load.
I wish that he would have been more direct with those charges and why reasonable doubt applies to each one of those charges. However, I do know that reasonable doubt was a huge issue in the first trial's jury, right? They had no idea what reasonable doubt meant. So I think the way he went about doing that was pretty sufficient. Tammy Fayette gifted 1 Valhalla Waits membership. Thank you so much. Appreciate you, Tammy. It went to Used to Be Younger. Welcome to the Goat Herd. You now have access to awesome new emojis like Fluffy here.
I gave him a B, but would have done C plus if I could. Yeah, that's the problem with only having 4 options. But yeah, it was from the cameras. It was for the jury, but I don't think it'll. I think you need to pound the jury over and over and over and over again about the reasonable doubt. That's just my take, and I would like to see the charges. Brett up there. Bev might have said he can't discuss the charges. She couldn't have said that because the charges is part of the case. So, of course, he can discuss those. You need third-party element to explain the injuries. Yeah, but you don't need... I feel he goes way too much into it. I would have stayed with saying... I would have talked about the third party, and I wouldn't have showed the thrusting video. I would have shown the come here video. Because the thrusting video, me and Valhalla are more rambunctious when we greet each other. And there's more butt touching. We need to put this in evidence. Yeah, it should be. It all depends on Bev's jury instructions. It shouldn't do that. It shouldn't do that. B minus or C plus. Beginning wasn't doing it for me. The middle was good, but then he went on too long and started to bore me, especially with third party. I think the biggest hurdle in this case is the third party, because the third party is really good for us. Because we have seen the players, we have seen how bad they are, and we have seen all the stuff that goes around us. But we haven't seen Brian Higgins. We don't know. We have seen Brian Higgins. We haven't seen Brian Albert. And we talk a lot about that fat ass idiot. Why? So I would have way more on the missing collision and why it applies to the charges. That's my take on it. But again, what do I know? I'm a stupid baker. Peck, he has a fancy blue dress today. Kind of weird, to be honest. Well, it's back to blue. It's blue is the color of the Justice for John O'Keefe, so that's why. And that's why you all got sick at Dollywood. Valhalla said it was safe sex as long as it was above the waist. But he said I should do a handstand, so everything was above the waist. I think they're relying on what the jurors from previous trials has been advising. It could be.
Well, and naturally people are going to want, okay, well, if you're saying Karen didn't do it, who? So maybe stuff that's not important to us might be important to several jurors, and maybe they've gotten that feedback.
And thank you, Vince Slotho, for becoming a member on, I think, Valhalla's channel. Why don't skeletons fight each other? Because they get boners? Shouldn't say that. Baker, you and Val have a weird long-distance romance going on. They see each other all the time, so they just as a lazy hump stage of the relationship. Yeah, that's called a wedding night for me. Well, that was no specs night. AJ has lost more dollars doing this case for free than any of us imagined. He wants this case done for that alone. The close was not for the cameras, in my opinion. No, it's for the jury, and but we are the jury. We are normal people watching a trial, and I'm just giving my because I can see when I go on the Twitch thread, everyone is sitting there swooning over him. And I sadly can't get there. It's not a masterpiece of a closing. I've seen better closings than this because I would have liked him to put up a demonstrative with the charges and gone through them, because I think they missed that opportunity in the first trial as well, and say, this is why you can't find her guilty in this charge, and this charge. And I really think it's important because we know the jury instructions are going to be wishy-washy. So I really needed that demonstrative saying, this is the law. They did it in, I think the defense did it in Sarah Boone and presented it well. They just had a bad case. But I really like when you tell the jury, this is why you in no possible. It's not because the community should feel that justice is done. F the community. It's because justice demands it when you look at the law. Hold your wild claws when Brennan starts. Oh, I'm going to be angry. Someone's looking ahead. Most jurors have made up their mind already. You need to do the reasonable doubt, but also just highlight the law too. I think Brandon and I is in agreement. I say high C, low B. That's where I am.
And everyone be ready. Have your emotional support snacks. We're going with Brennan.
Yes. And again, you don't have to agree with me, because on this channel, we don't do safe spaces. We have a Brandon. But we are also fair and honest in our discussions and see faults in both sides. I will do another, but I'm not sure I've even put A on it for Brennan. But in fairness, I will put one up when this is done. So I'm glad he brought up the fact that Jen McCabe never bothered to go check on her sister. Only way she knew they were okay if she had spoken with them after John O'Keefe. Yeah, for me, that's the crucial point in this entire case. This is where I believe that phone call in the morning must have been, oh fuck, she woke up, she's looking for him. It was, again, this is pure speculation. My take on this is something happened. Probably an accident because there was some roughhousing going on. Someone might have needed a beating and it went too far. They dumped him outside, and it was that donut thing we always do for his birthday was supposed to be when they found him, and it would be a slip and fall, and oh, we're so sad that it happened. He took an Uber home. That's, in my opinion, that's why Brian Higgins went to the police station, to be on camera, and then Brian Albert would testify that, well, John left the house at around 2:00. But that's pure speculation. I have nothing other than pure speculation to have that in. To me, that makes sense if you're trying to hide a crime. They get into a fight because Higgins come up and say, I gotta bang your girlfriend, or I banged your girlfriend, or something like that. Got into a fight. Something happened. And they tried to cover it up. That's my absolutely wild speculation. But let's get into Brennan. I'm going to do the same again. We're not going to stop. We're going to listen to all of it. We might poke our eardrums out, but it's going to be wonderful, because truth don't matter in the court of law, at least in this court of law.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, could give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole.
He's aiming for
She
the
was
third
drunk.
charge.
She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken. The samples of the retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data.
No
Temperature on
healthcare
the battery of
data.
the cell phone. The physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you got to get help. You got to get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described to you one time, to get away from the scene, he walked into his bedroom, but the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages. Now it's all lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keefe drinks a lot and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober. And then at the waterfall, a shot, a mixed drink. Now, it was brought up at the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Can we have slide 1, please? At the waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins. Barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not Tom said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
Alcohol intakes, probably about 5 or 6 or 4. The drinks that they reported at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like old soda water with blue lime.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15. I mean, it was quiet. The roads were very quiet and see the videos. And I was going, when I've had a few drinks, I drive, it was very slow. And go my alerts aren't as sharp as they should be. But I shouldn't have driving.
Thank you. Do you think she drank when she got home? When they leave the waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key critical piece of this case that did not exist before. He found it recently. And it was that SD card, the SD card that everybody missed. including the defense expert, everybody interested. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said this at the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it, and he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows
Say
when he
healthcare
does
one more
not
time.
move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Slide 4, please.
Very close to the Alberts. In fact, when Jen was navigating John to the Alberts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
So as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that a little, please. And it shows you with the healthcare data, it registers as flights climb, but it doesn't mean someone's climbing upstairs. What it means is an elevation. And he breaks down the data, the red, the green, if you can move down to the moment. And then the bottom left, that's 34 Fairview. You can see second by second the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. It's a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorger comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there. They're together. The data matches up perfectly. Perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They follow behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it. Because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. They didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nagel said they're there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Miss Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves to 20 seconds. Ian Whitman said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone, at that point, you can tell exactly what John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he's always near the flagpole. He could have moved. He could have moved in the circle to come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves to 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door from 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stops at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing. It could be a straight line. It could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds, he's moving. And in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, Gemma Kate. And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. But like knocking on the door, like Kaylee said, getting the last word, she doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Ms. Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Ms. Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not.
She didn't hit him.
What we are obligated to prove and what we have proven from the evidence in this case of second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear plain, strong likelihood of death. Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge, and they see cars going by, and they have a boulder, and they want to throw the boulder off. They're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge, and it comes down and lands on the car, and there's somebody, passenger, child, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton. It is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with him. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever the disorder wants, it stops moving. John O'Keefe stops moving. Forever. Forever. Next slide 6, please.
He's been gone for roughly 40 minutes.
You'll get to see this more closely, and you can't probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCA, they did some crash tests on me. You know what else they do? Text stream data. There's nothing about that data that is uncertain. Nothing. Take that down, please. When Miss Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry.
What?
You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12/31/56. 12/32/04 to 12/32/12 is the data which is adjusted when you reconcile the box and the Alexis. 12/32/09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12/32/16 is his last steps. As the disorder says that red range should move a little bit 2 or 3 seconds, they can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We can have slide 10, please. Play that, please. Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly lays on the ground, abandoned, you're going to have to ask yourself a question for charge number 3, leaving the scene knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge,
Look at Lally's face.
She knew she hit him. We weren't there, but there was an eyewitness. There was a guy.
It's like I tried all this last
and that
time
eyewitness
too.
tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. We have slide 8, please.
Oh my God, this.
Could I have hit him? Did I hit him? How did that happen? I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo, and I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up the cell phone, and I ran over his foot and then passed out drunk? I mean, I didn't think I hit him, but could I clipped him?
When she left Fairview and left John behind, she didn't think he was mortally wounded. She knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. Can you play voice no one, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, So was John O'Keefe. And him and his cell phone alone on that yacht. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not the same analogy. The idea that means that John O'Keefe was in the house, absurd. 66 turns to 61 is 12:53. 48 unanswered calls from the defendant. He's not in a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, his cell phone would be moving. There'd be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps because his phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm dealing with a fucking kid. Nobody knows what the fuck you want. Fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him and now he's not responding and she's getting nervous and she's getting anxious and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. You can take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, where's John? She doesn't call Brian Higgins. Has his number, has been texting with him. Hey, was John at a party with you? Did you see John tonight? She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. Call Jen McCabe. Call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, I left him at the waterfall. I left him at the waterfall. See, now it's gone from panic to self-preservation. I left him at the waterfall. And Jen says, left him at the waterfall? We saw you in front of the house. Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. She calls Carrie. John's dead. I think he got hit by a plow. Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that for what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce. And she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts separately at that time answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch has showed you all of those demonstrations where you can see the unsettled snow in the back, and after the bump, you can see the pieces missing. No taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing because it's back at Fairview. That's why it's missing. It's not there. It's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about.
Sorry, I should be fair. Then put that picture up on the display so you can say, look, it is missing. I have a picture. The next time you say healthcare data, I'm going to go pound my head so hard into a wall that Marissa has to end the stream because I will hematuba myself. You have all this evidence of all these things happening, and you haven't shown any of it during this trial. All you rely on is them thinking Karen is a bitch because she said what she said in those clips. Your entire case rests on Karen coming off as a Karen. And what the hell are you talking about throwing stones off a bridge, killing people? This is... I get a lot of flack right now on Twitter for saying C+, B-. This isn't registering on the scale for me. Fuck it. This is worse than I thought.
How is he going to say, okay, there was no one, not one of their experts says it was a car, but now he's like, well, she was a mastermind, so she thought, well, it was a plow. That body would have been tartar had he been hit by a plow.
And again, this criminal mastermind came home, started calling him because she knew she hit him, killed him, left him on the lawn, but still called him and took away her alibi, maybe, then sat on a couch without moving for 4 hours, then broke out of her drunken stupor, said, oh my God, I killed John last night. I better go wake up his niece. Instead of just leaving him to be found in the snow, she panicked in a drunken stupor, woke up the niece and said, can you call Jen McCabe and ask what happened last night? Because that's what a reasonable person would do. And then they called Carrie, who's just a regular soccer mom. And she, from the goodness of her heart, went out looking for her. After Jen McCabe wasted 30 minutes making coffee, and not one fucking cock of a man in Canton said, ladies, let me drive you. The weather is bad. But have any of you gotten hold of Brian? Because remember, we saw her car at Brian's house yesterday. Maybe Brian knows something. Not one person had that thought, but they're just regular soccer moms who, out of the goodness of their heart, and that one time they met buying Reeboks, went out looking for John. Karen is a bitch.
Can we also acknowledge the fact that these regular soccer moms admitted to lying to the FBI? Just throwing it out there.
Well,
can we all?
That's what regular soccer moms do.
Apparently.
Well, I'm just glad that he gave me permission to go make fun of Shannon with one N. I'd been waiting for Hankey's permission.
Brendan, Hank is throwing some wild pitches, but he's aiming at the right plate. Yes, the jury could pick this up. AJ yet again has tried to get Karen convicted and may have succeeded. He could have addressed any of this, but chose tall tales. I don't know if he's trying to get her convicted, but I think he should have preempted the video clips. Because to me, the only thing that the Commonwealth has is the video clips. Because, yes, Karen doesn't sound good. It's the biggest mistake I've ever seen in a court case, except the guy who stood up and said, I'm sorry I did this to your mom. That really didn't help his defense. Jackson closing, Baker no reaction. Hankey's closing, Baker wants to scream. Exactly, Spire.
Yes.
And I think that's it on Valhalla's.
My brain now hurts.
Oh, no, that's on mine. And thank you, Spire, for that. Let me get a tag.
Valhalla, I have now had many rage drinking. I'm on the verge of joining it, Em. On the verge.
I'm about there.
That
it is
impact
afternoon.
will jack your healthcare data up. Brendan, I will find you. I will do things to you that Jamie has taught me. And
skills.
I'll just say she has a trick she calls the TSA agent. No loop, and you will feel it.
Jesus Christ.
And Animal Rumpy, thank you for the 5 gifted Rumple memberships. Whatever that is, I still don't know where to see them or find them. And remember for 2
Thank
months.
you for breaking up Hank's lies, Baker. Remember for 2 months. Appreciate you, Hellfish. Appreciate you.
This is so stupid.
Oh, God. Can't
Again,
be over yet.
I could have stopped and said, don't go so much into that hip thrust thing. Didn't like that. That's why people are yelling at me, because apparently you can't have any criticisms of AJ. I think it's fair. We should balls and strikes evenly. But this guy is infuriating, deceitful. And again, Doink, and I've waited my entire life for something like this. He can't say Apple Health data. This idiot has spent 32 days talking about healthcare data.
Yeah.
I want to beat him with a hammer.
You know, the people that he keeps listing in his closing as arbiters of truth and whatnot. Jen McCabe, Kerry Roberts. He keeps saying they heard it, they did this. It was Kerry Roberts out of the goodness of her heart. Well, I don't think those witnesses look good on the stand at all. I think those witnesses came off looking like liars that were trying to cover some shit up. I don't think this is a good closing by any stretch of the imaginations.
Brendan, I'll healthcare data you so deeply.
I'm going to need HIPAA forms from both of you. If you're exchanging healthcare data, you do need to sign a HIPAA consent form.
This is why Brendan is doing this to me today.
Damn.
Well, as long as you keep talking about your healthcare data, you can't get a member chat. Jamie has said that over and over again.
Yep.
All right, let's get this nonsense over with.
Yes.
Jamie, it'll be best dry arming Baker. It will be the best dry arming Baker will ever have.
Dry arming? Went straight from finger to fist to arm.
Holy ow, past the elbow.
Gross.
They make a glove for when you got to go inside of a cow. They make a glove that comes all the way up to the shoulder. Just for reference, y'all.
Oh my God.
I just don't
that's
know
how
why
we get
she.
Baconators?
I just don't say why she said it'll be the best one ever. The last one was pretty good.
The last one wasn't too shabby.
It's got. Did you ever watch Road Trip?
Yeah, with Tom Green and the giant leopard.
Yeah, and in the end, Sean William Scott better make it 2.
Better make it 2.
5:35. 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down. Can't understand her. Going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch?
Because he didn't come home, you idiot, and she can't get a hold of him.
This extraordinary duress.
He hasn't ever had a partner, so he doesn't know that
She just see
fear.
death.
He's got a wedding ring.
Kerry Roberts comes, take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to come
At least 12
We're
minutes.
going back to Meadows. You're going to follow me. Leave the car. I'll drive. At this point, Jen and Kerry don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Kerry Roberts, Jen McCabe. They're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything.
There was enough snow to track a cat, you idiot. Your own expert said it. No, sorry, don't break it up. Don't break it up.
And they're driving
Be
and
fair.
driving, and they decide they're going back to 34 Fairview, and this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close.
What's remarkable?
And when they get close,
Oh, he lost his spot.
they can see nothing.
She saw John before anyone else did.
But the
That's
defendant
remarkable.
screams, "Stop! Let me out!" And they look around and they say, "What? Let me out! Let me out!" She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone, so you probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Right. A weird shaped lump in a blizzard, and you equate that to John O'Keefe. A weird shaped lump, not like a bush, and that is John O'Keefe. She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen, and she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him. You're going to see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose.
On the other side, you idiot.
And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert House. The glass, well, you will hear in the clips, if we don't play it, we'll have all the clips with you. She talks about the fact that he took the glass. He took the glass. She says it. So the Albert House, they don't need to get the glass. He already has the glass. Put the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McKay makes a call to her sister, and they say because it registers 29 seconds, a cell record is not the same as a call detail record. There's no evidence. There was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can ring. It can go to voicemail. They have no evidence, none, that there's a conversation between Jen McKay, the person who was ripped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McKay see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there was not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time has anybody said, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road.
Mo, if you found your husband dead, would you have asked what time did he went into the house, or would you be screaming your head off and trying to get him back to life?
I would be screaming my head off. I mean, and here's the problem with all of this. The fact that she says, I take nothing Karen said that morning for any kind of close connection to reality. You know, her saying she picked the piece of glass off and it spurted, you know, again, none of this really made sense to me. This is just dumb. This is all dumb. And are we saying that Carrie and Jen, now their best friend is John, and yet when you call 911, some guy's on the front of my sister's yard?
Mm-hmm.
Yeah. Stacey Labruni says, I don't healthcare about disclosing. That was a good one. Perfect use of the word healthcare. Hey, guys. No, I can't do a Vice's voice. Hey guys, just popping my head through the dirt. Just remember, Hank is arguing to the 12 ignorant slobs. P.S. Someone sent whiskey. It's dry down here. Dark, but on Friday the 13th, I'll allow it. Thank you, Brendan.
Like
Yeah.
Mr. Rensler or Mr. Wolfbanks. He's right there by the side of the road, close by the curb. Do we have slide 14, please? You can see there's Terry Roberts' vehicle, and then on the left, you can see where they're working. Right off the road. That's not funny to you. That is a clip, a stubble, and a fall. Remember when he fell, it wasn't snow. It was just the beginning of adjustment. It was the cold, hard ground. Remember what Dr. Isaac told us about cold, hard ground? Causes this type of injury all the time. All the time.
That's not what he said.
We could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass. That he took from the car, from the waterfall. And then Exhibit 195, matching glass. On February 3rd, the matching piece of glass.
Where's the rest of the glass, you idiot? You found the straw, but the rest of the glass is gone?
The glass was found with Mr. O'Keefe.
No,
Was found on the
shut up.
street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail, to memorialize what happened to him that night. Remember the straw? I asked you to take a look at that picture, leaving the waterfall at 12:12, the black straw in the drink on the street. Collision, glass, nose, straw, back hits his head. Can you play the clip on the left, please? 59.
So when John got out of the car at Ryan Albert's house, he took my full bottle of soda, which is sitting in the cup holder.
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you've heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics. They've been getting to work 2 hours early to know the blizzard so they get there on time so you can help people. These are the core of our communities. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody. But for him, it's another human being. This is his passion. Katie McLaughlin, first responder, this is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene.
Who have ever said that?
Some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. Anthony Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with it, so she has to bring people with her to face it. And now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent core people who hear her say, I hit him. I hit him. And the attempt is to betray.
You don't have independent core people. You know that, you fucking liar. You have one person who claimed, I heard her say it, which is McLaughlin. Then you have Nuttall, who claims that he heard it, but it wasn't important. None of these two assholes ever reported it. You're so fucking full of shit.
Everybody is a liar. We don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
Did I always said I did, but did I really say this many times as law enforcement explaining I said it?
Okay. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself. She hit him. It's undeniable. It's unmistakable. It's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Ms. McLaughlin hear exactly that. She tells you. And Jen McCabe, When she's sitting next to or standing next to Ms. McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, ironic thing is, you will see in a photo when Ms. McLaughlin, firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of the story was trying to help the defendant from incriminating herself. The irony. We have slide 9, please. This is the battery temperature. You're gonna have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, they'll leave the waterfall 82 degrees, 12:22 in the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it started to go down 72, 12:45, 66, 12:53, 61, and you see it drop and steady off at 1:36. Remember, cell phone battery under John O'Keefe, either struggling for life or he's passed, and the blood's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Terry Roberts goes over, takes up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not coincidence. That's fact. That's data. And then the phone is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that's under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in a cold. And there's Ms. McCabe in her winter jacket, soccer mom, trying to help. She has MS. Her hand's not working. She's trying to type in what's happening during that time. It's a frantic scene. She tells you that the defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again at 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. That's what she did. And what happens to her after? Because of the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Pocketmark Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that's being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration of how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolfram Harker knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27. Look the other way. Don't look at what she did. Former Trooper Proctor. Look the other way. Don't look at her.
Oh, he's stealing AJ's
maybe in the
from the
basement.
first
Look
trial.
the other way. Don't look the other way. Look at the facts. Look at the data, and it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction, disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. But that doesn't make it starting to. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper Lieutenant was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't.
No, what he wouldn't say he was dishonorable either, you fucking pillock.
Doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning?
How about every fucking video you put into evidence?
Those were taillights that were only found by Super Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there's any evidence of tampering, not that there's any evidence that it was not true, but I didn't put that evidence before you because we didn't need Super Proctor in this case. We don't need Super Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you.
No, that's not why.
Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan, Mr. Proctor, did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house, inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight cap of snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the cage. He's not even on the scene. He's been near the car. And then the Dighton videos themselves, when you look at it at an angle and it moves, but if you get the right angle, you can see it's missing. It's
Coming up on an hour 15.
507. You can play any angle you want. If you look at this angle, it's gone. It should be no plan. It's already gone. You know where it is?
It doesn't look like what it does now, you idiot.
Look at the right-hand side. Look at the left-hand side.
Roughly 115.
It's gone. It's gone. And the same thing, when you do videos, it's a different angle, a little smaller, you can play that and watch the lights go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the solid core, couldn't have been it. You gotta ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in the conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can convene to get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not.
It would have definitely taken
And
longer
then
than 2
he
hours.
claims that the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I showed him that bottom right photo with the snow, with it missing. And I say, is this the way it looked? That's, of course, before the snow melts out of the salad board so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no pig into the salad board. There's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Terry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back.
Oh,
So
why is that?
Now, when we're trying to look the other way,
Because
we want to find
someone at the
Dr.
police station deleted it?
Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here.
I haven't sped
She
up,
can't explain
that's why.
methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, and then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack.
He's not.
That is
The defense had an hour and 30 minutes almost.
Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures.
This is a fucking lie. She
She's
wrote
gaslighting.
2 papers on dog bites from the riots in '92, where the police used dogs on protesters. She wrote 2 peer-reviewed papers on it. I know you don't have to be truthful in closing statements because it's not part of evidence. But you have misstated what Barrows said. You have misstated what Dr. Russell said. If you have to misstate what experts said on the stand, it shows you have no case, you fucking idiot.
Not to mention, I know, but this was about John, right? So we have now spent officially, again, more time on Jen McCabe, like we did more time on this case on Jen McCabe than we did on proving that Karen Reed hit John, again. It's irritating.
All evidence that she hit him is healthcare data and an animation of a car moving that he can't prove hit him at any time. I see we've entered the gaslighting stage. Yes. Fact in evidence. If Baker has this sped up while I have this sped up, it's actually more coherent. Yes.
Ooh. Can we get Inception's level of speed up?
Why is the defense not objecting to this misstatement? Because you normally don't object during closing arguments. You'll rely on the jury. And it's not egregious enough that Bev will just say, I'll allow it. He should be about done. We're 5 minutes behind, but
Oh, thank you, God.
he should be about done now.
In all fairness, too, if the jury recognizes that he's lying,
yes,
don't object. Let the jury recognize that he's lying. Let him lie to the jury. Let him.
Yeah, and if you don't think those 3 lawyers aren't looking to see how the jury's reacting.
And according to Sue, people are paying attention. So, yeah, to him.
If she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. Laposada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. How is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about
Because, Hank, you fucking moron, she's an ME. Do you know what an ME's job is? It's not to look at the debris field. It's not to listen to Jen McCabe. It's to look at the dead body and make inferences from the injuries or lack of.
I almost want to say do one for me, but then I don't want to be responsible for you hitting your head too hard.
I'm going to make myself get a hematoba.
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 She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Just write that in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she in 90 days saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries. The suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people get plowed over by a car, have no injuries. Some people get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there's no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you? They're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We heard words like confirmation bias, objectivity. Mr. Wolf got on the stand. And before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert, what objective expert
No way.
uses signal, and encrypted out to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all. And because the lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Retchell came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. So you adjust it. And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brennan asks you a question, make sure you ask for the transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders.
So maybe call out your bullshit lies.
And so what happens with Dr. Renshaw, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. He said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and effective. I asked him about a lunch, and not a big deal. Just ask him about it. And he says, I have a sandwich and I stand in the corner until I remind him that we got video footage from a documentarian and he's in one of the scenes. And then things change. So when you talk about objectivity, who to trust, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judge Welcher, Dr. Welcher, never suggested that in his work on texturing data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk. She hit him. She left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Can I have slide 19, please? You bet they can.
Yeah, but then the rest of the evidence doesn't match up, you stupid.
This is Bible. Look at the reveal. Look at his turn. Remember his sneaker on that curve? Like a lot.
So
Then
is
how
the
did he
hoodie made
come
out of
up
adamantium?
8 feet?
Hits his head. Counter coup. Left to die.
He wants it both ways.
Our
Did he not
time is
complain
sneaking
to
up
us?
on an hour and 30.
What happened that night? There's no doubt who did it. You have a very difficult task ahead of you when you consider the evidence, you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down your driveway if your kids were at the end of the driveway. You would say, we're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. Oh, you had manslaughter, she's drunk, she was reckless. She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I
I'm
have
gonna cry,
slide 2, please?
bitch.
He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe is a person. And he was
What the
murdered
fuck did he just say?
by Karen Reed.
He said a buffalo on a prairie.
What does that mean?
Take that thinking.
What
Jurors,
does that even
next up is my
Was that his closing? I'm
Yes.
sorry. I'm just gonna go down to normal speed because to me that was kind of like a wet fart in a church.
He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person.
Well,
And he was
we know
murdered.
that. It's not.
By Karen Reed.
Yes.
What does it say?
take that
Oh, he's
thinking.
just a buffalo
No, I
on a
think
prairie.
Karen said
Jurors,
that he was out in the
next
middle of
up
the
is
field
my
like a buffalo.
Instructions to you
Oh,
on
yeah.
the- I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back to lunch. It's going to be a shorter lunch. My instructions are long. And we want you to be able to get this case to start deliberations today.
AJ
So,
125,
going to
Brennan
send you back in
120.
About a half an hour. Is that enough time for you folks?
Half an hour.
All right, so we'll give you a half an hour for lunch and then we'll come back. I'll give you my instructions.
Why do that?
and then
Why not?
you'll,
Because they need lunch, then the instructions, then they get it.
receipt only.
I know, but it'd be
because they need lunch. So either you give them lunch now, or you'll start reading, stop in the middle, and give them lunch then. This is actually a good thing. AJ closing, try to be objective. 51% says B, 38% says A, 7% says C, and 1% says D.
And mine says, Hank, you only lied a little bit. She's all the guilty, and FFF.
AJ's closing argument grade, D or F 3%, C 10%, A 33%, and B with 53% in the majority.
Oh, I just put mine up because I thought we were going on the, poll after done.
That was AJ.
Oh, I was.
Yeah, we're gonna do the other one now. Oh well, I am.
Same.
Oh.
Can I only go as low as C? D? Sorry.
I put D and F in one category.
Oh, so you guys were keeping up your AJ poll the whole time. I had taken my AJ poll down and put up the Hank poll.
Well, I'm putting my Hank poll up now.
2 L's, no E in that poll for Hank, though.
Ugh. I'm gonna use the same wording and the exact same options, even though
I refuse to be objective. I changed the grading.
Yeah, everyone is just
Look, when Mike
option
and Ike's
5.
can't help
I
you-
can't be objective.
Look, I gave him 10 healthcare datas, and then after 11, I was like, screw you, dude.
I trying to be objective and try to look at this. If I gave a high C, low B, I can't even get into a C for this one because there were so many misstatements. He never, ever at any point tried to combat any of the facts. He just said Arca used Signal app. I use communication apps every single day that's encrypted. It's just, and how many experts has ever been impeached? Well, your experts didn't turn over anything, and they changed their statements. What was amazingly missing from the state's closing arguments were any data other than the car moved. And he said, he gave the jury the reasonable doubt. We never tried to say how she hit him. Well, that should be reasonable doubt.
Baker, didn't he used the video from Arca that showed that he would have had a shattered elbow, radius ulna, and humerus. Not to mention possible dislocation at the shoulder. He's like, it's possible, though. It is possible. Damn you. And let's be, can I don't want to hear about Jen McCabe.
I wish the Arca had used a ballistic arm to show the injuries. That would have been better.
Yeah.
He literally said they don't know what happened. Yeah, that's where the reasonable doubt is. He said, all we have is healthcare data and a car that moved. We can't tell you when it moved, how it moved, but trust me, bro, she hit him.
Oh,
we
and
can't
I like
prove...
how he said,
Go.
I wish she would have had that, shame she didn't have that acute grief when she drove past his, slowly cooling corpse, earlier that morning, when she already knew.
Yeah, and again, is she out of the woods? No. Juries are notoriously weird. What will kill her case is the videos. It's the biggest mistake ever made by a defense team, letting her talk to those interviewers. If she gets convicted, it is because of those videos, because there's no facts anywhere. And juries are notorious for going with fifis instead of facts. So I wouldn't say she's out of the woods. I would say that Lally put on a better case last year. That's all I could say. Doink, Hank Brennan has just changed the discipline of American law. Hank has just set a new standard for what it is to deliver a closing argument. I hope he get his little whistle wet in the fake victim, because
Oh my God.
with all this
Doink,
gaslighting,
whatever you're smoking, let me know. For science.
yes, I can see that anime. My God, I hope the jury can see how out of context the clips are, and at least please let them fight about it. I still think we are in right now. If I should be given my prediction based on this, I would guess a hung jury.
I can't fathom a reality where 12 people find her guilty of any of these 3 charges. It seems improbable, to say the least.
Yeah. Everything that guy just said is bullshit. Agreed,
Bullshit.
Sebastian. M-Spire has no cigarettes. It's late here in Oz. One more drink and I must go to bed. Well, M-Spire, get to bed. And
Yep.
You got the
'cause now
closing
we get to
Valhalla will
hear
do the
Bev.
drinking.
Yeah, that's the important part.
Yeah. We get to listen to Bev bloviate.
Yeah. Just see if anything was said.
How did the 6-pack venture pan out?
I got it here. I showed it to you earlier.
I missed it.
Oh.
I don't like these. I'll drink it for you.
That a boy.
Brendan, don't say I never do nothing for you.
I appreciate it. Oh, Volstorm.
Hung on what charts? I don't think there's murder 2 anywhere near this, but I think they can get hung on the manslaughter charts. I don't think they will retry the case, but it'll forever be. It'll be like Rittenhouse. Well, he crossed state lines.
Lally, I believe Lally said that they're going to keep trying this case if it gets hung again.
I bet you they won't do it. Brandon is going to be facts don't matter. Play to the retards. Address the charges. I still believe that the biggest problem with AJ was he didn't address the charges.
Yeah, and
Yeah, I
if
wish
there
he
are
would've.
any one of the videos that you would want to refute or get a more context, it was, even though you could clearly hear her say, could I have hit him and left him mortally wounded? That would have been the one I would have cleaned up, because that's the one Hank is going to again try to manufacture this. She didn't render aid. She didn't give him. She knew he was dead to begin with.
Yeah.
Man, you can almost spell struck.
Crusty.
You can almost spell crusty. this puzzle
Oh
is.
my God, we need to make a Karen Mad Libs.
Oh, terrible.
That doesn't work again today. If you want to play while we go make ourselves some dinner, there is a QR code. Oh, does it work? Maybe it works. I don't know. Oh, it does work now. It does work on my chat, but if you're in one of the other chats, you can take the QR code and you can play along with us. We will be back to listen to Bev drone on for approximately 2 hours.
Oh, God.
About nothing. And then we'll have to see what, if any, happens.
Yes.
Update your
And
band.
I'm going to put on some musica, and I'll keep an eye on it, but I need to go make some food because...
Can I put a request for Weather Cat?
Yeah, but it can't play all the time. People get cat of it.
Right.
It's side of, and I only has it as a music video, so it'll take it away.
Oh, right.
I remember that guy. I remember that guy.
It's Jamie's best friend.
Yeah, it is.
Oh. Who?
This guy.
Your work buddy.
Oh, the sneezer.
Yeah, the sneezer.
Oh, good Lord.
I miss him. I wonder what he's up to.
He's probably sneezing.
Probably killed himself sneezing.
Died from a brain aneurysm from a sneeze that he tried to hold in.
Finally, yeah.
Whole head explode. All right, I'm going to get some food. Y'all have fun.
Yes.
Everyone, if you're in one of the other chats, you can scan the QR code. If you're in my chat, you can use the chat. And I know that it says you need to scan the QR code because I'm too lazy to change the settings. We will be back.
Yes, yes, Space here, please.
Hold 1 second.
Okay, Paul.
You guys to the jury.
Oh, okay. All right, jurors, I'm going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict, but before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly,
If you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case.
Well,
You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and
Aiden Carney, during the break, Bukaki was standing menacingly in the hallway wearing a black suit, eyeing the jurors up and down. Karen Reed's lawyers complained to court security about this, and he was forced to go inside the DA's office. I would have taken a picture if I could, but he was literally standing there in the hallway with his arms folded, dressed like an Eastern Bloc men in black, and the jurors were all forced to walk by him. He was also upstairs when the jurors was first brought into the courtroom. There is no reason for him to be here today. Well,
not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged.
Remember when Hanky in his closing said that was weird that they did an interview with Officer Barrows? Yeah.
To prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answer.
Sorry, Hank's closing tried to be objective. 66% D, 25% C, 8% B, and 0% A. I am on a D because he, as I counted it, made reasonable doubt arguments 4 times. We don't know how it happened. We know it happened. That, to me alone, should toss the case because that's reasonable doubt. Sorry, Sue, but I just wanted to make you feel good. I can put up.
If we're ending the Hanky poll, I had 21% C and 79% D or F. No A or B.
And for my Hank poll, we had 87% said triple F, 10% said he only lied a little bit, and 3% said she's all the guilty.
How many?
I use Common Core math to think that one up.
3% said all the guilty. Interesting.
Well, I think that's a reasonable amount in our, because if we see the court TV and stuff like that, they are in 15% range, and we do have some people, and again, it's fine. You're more than welcome. We agree to disagree.
Objectively, if I wasn't paying attention to the facts in this case, Hank did that slimy prosecutor thing where this is my fallen brother in blue. This man didn't deserve to die in the cold. He did try to tug on those heartstrings. So, there are probably a few people out there. I mean, Plevin has to talk to someone.
Yeah. And as always, after ending closing arguments, we will do the what will the jury find? Now we get to be mind readers. I can tell you I've watched both Aiden and Sue's observations of the jury. All of them seem to have paid its attention to both sides. The only one is jury number 6, but she apparently has a resting bitch face. So, and as a fellow stone face, you can't tell anything from that. But I have put guilty manslaughter, or not guilty as the options.
Answers to the questions and the exhibits or evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict,
Dan Davis, thank you for supporting one of the others. He only lied when his lips was moving.
That was for me. Thank you, Dan Davis. Yeah,
For
but he did
particular
that little
indictment-
quiver in his voice like he was going to cry.
Yeah.
the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is.
I think that was the
You should
N-word.
evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically.
Ballstorm, I think it's on your end. Mine is fine. I don't have any hiccups today. So I think maybe refresh the stream. There have been a lot of problems streaming from StreamYard to YouTube over the last 3 days. Could possibly also be that yesterday StreamYard was down totally.
Yeah,
so,
it was terrible.
Yeah.
I'm getting a couple little
Automatically
glitches.
believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your.
Well, a partial split verdict. Last time she said you can't return till you agreed on all charges. So this time she will allow them to come back with a not guilty hung or something like that.
Life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation.
The first time.
You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken.
And Dan Davis, I am one of those 5 out of 4 people can't do math. Makes sense to
Under
me.
the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them,
we didn't see anything because the niece was the one who mentioned it, and she was not on television. She's 16 years old.
Your verdict must not in any way be influenced by the fact that
She yelled at John for kissing a 25-year-old. You know, women can be a little judgmental if you're kissing a 25-year-old.
Kissing and hugging.
That's
Sullivan slut.
Hey, just because she puts out doesn't mean she's a slut. It means she's easy.
I said what I said, sir. I said what
Fair
I said.
point.
Yeah. Hey, it's the same with me. I have low standards at 8 p.m. and no standards at 2 a.m.
Lower your standards,
photographs may be
raise your
graphic or
average.
unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by
Aruba was out in the way they didn't call the Sullivan sisters, but Aruba came in through the niece. We just didn't hear it. Kelly DD, thank you so much for gifting a membership to Ralphie herself.
John
Nice.
O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it.
Val for Top Mod 2025. A fake mod is still a mod, baby. Woo! Hit him with that Ric Flair.
Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth...
Yes, the poll is meant to be what the jury will vote, not what you would vote on the jury. Correct. So we're just saying what we think they will find as a result.
Is proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about
because
the fact
that's what they were instructed. Such
inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first of my instructions. Woohoo! Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now, I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any...
Last year, instruction lasted an hour.
One of these 3 prongs beyond...
Trial. It's actually kind of short for a U.S. trial, an hour.
Yeah.
Yeah.
And it's an amazing waste of time. The second part is the only part we need. What are the charges and how do you determine if she's guilty?
On a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of
Karen
alcohol?
was driving. That's where
It
what
is
the
not
witnesses
illegal to
said.
drive after consuming alcohol, as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely, by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove.
We have her driving by the way of Ryan Nagel, but he testified that she actually operated the car in a safe and secure way because she was using blinkers, she wasn't speeding, she wasn't in his lane. She even tried to stop and let him go first, and they waved her on. So she was absolutely not recklessly driving.
In an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent, even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her
Yes,
vehicle.
we had two people talking about the
defendant's,
test.
the condition of the defendant's vehicle, what kind of road it was, and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produce the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another.
Am I the only one so effing bored?
No. But it's okay. We got to get through it.
No.
We got to get through it.
I'm over here
Yeah.
trying to remember all the lyrics to the Aqua song in order to stay awake. So thank you,
Which
Baker.
one? Which Aqua
Baker
song?
knows him. Baker knows him.
The Barbie Girl song. Only I'm trying to do it in Baker's voice.
I'm a Barbie girl in a Barbie world. Life and plastic.
Okay, we can't pause it
it's
because
fantastic. Well,
she's gonna
I
take-
can speed it up if we take it a
Oh,
little
yeah.
bit. That's why I'm trying, because she
good idea.
talks so slow. I love that she said you have to rely on my spoken words, and then she makes mistakes constantly.
she said her oral instructions, and I'm thinking it's too close to to lunch for her to be talking about that.
Oral is always on the table. Just going to let that one rest.
It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently and
she's reading all the sub. That's what they got hung on the last time. There must be some kind of unaliving, as far as I read the Massachusetts code with the charge against her. I don't think there is a pure DUI in it, which is not a DUI in Massachusetts. It's a OWI, but all of this is the sub charges that goes with the OVI manslaughter, the reckless homicide, and all of that is in there. But I think there must be a death. You can't just say, well, she was drunk. But I still believe if she's going to get convicted on anything, it's on one of the lesser included in the OVI manslaughter.
Manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. It can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI.
So they are able to get
the
an
third
OWI?
indictment is leaving the scene of if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI.
Interesting.
So the third indictment is leaving the scene of an accident result.
But let's say they find her guilty of OVI. I will bet you my Friday beer that at that point, all the Spurks will say, well, it's clearly she's guilty of all of it. They found her guilty. Yeah, drinking while drunk. Yeah, so she killed him. That's not what it means. Yes, it is, because there was no manslaughter. Again, with a clear DUI charge in there, yeah, I think she'll be found guilty of DUI.
100% yes.
So she will be found guilty of something because she admitted she was drinking. That's what I say. But the cope will be 24 karat.
Who said it? Somebody in chat just said the perfect Where'd it go? Yeah. Napoleon STP. Just think the state spending over $1 million on an OWI.
Yeah.
Wild.
Sorry, OW. We don't have W's in Denmark.
Whatever
so
the
I
hell
call
it
them
is.
VIs. So
Operating under the influence, operating while intoxicated, driving under
Yeah.
the influence, whatever. It's all the same thing. It's all the same thing.
drinking while drunk is a crime. Yeah, that could be public intoxication.
I wasn't in public. They threw me into public.
Yes.
Is cross-eared a word like cross-eyed for your ears? I'm cross-eared right now.
I'll allow it.
But your ears is pointing that way. So in Denmark, we call that wind-eyed when you have that where it goes in each side. So your ears must be wind-eared.
Wind-eyed?
It's because the wind had blown them to either side.
Oh.
I told you this when we were driving last week.
I don't recall
we call
that.
that wind-eyed.
Sounds so much worse than cross-eyed. Wind-eyed.
We
the wind
had
blew them the opposite direction.
the former head of my HOA has that. So you're constantly standing there like this.
And you're trying not to pay attention to it.
Yeah, because you're trying to, because you've been told, look them in the eye, and you're standing. Which eye?
Which one? My youngest, most feral, would shout that. Like, which one am I supposed to look? They don't go the same way.
We should call Valhalla Jimmy 2 times.
Jimmy 2 times.
I call him Valhalla Good Times.
Hey, yo.
In death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay, thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law...
No, these instructions are boilerplate. There's nothing in them. That's what they talked about yesterday. Lawyers will try and change things, and she said yesterday, I think I have to give the full... They didn't want all the parts of the OVI, but she has to give them because that's the law in Massachusetts. It's just boring, and it's repetitive, and the jury gets it. And normally the judge will say, I would urge you to go back and read the instructions again. So, yeah.
Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected,
So
She's
random
not
last
charged
year.
with simple DUI, but DUI is part of the OVI manslaughter case. It's a lesser included in that one.
as an alternate juror, please do not feel that your efforts in this case have been wasted, because as
would-
I've
I
indicated,
would
it's
stand up
important that
and
we
yell
have extra
if I
jurors
got
in case of an
picked.
emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson
didn't
of a
in the
jury has
Turk
been
case.
described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case?
Nope.
I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charge.
Valerie, not Valerie. Middle-aged black man that never took notes is juror number 5, who's seated in number 1. Juror number 6 was the one that everyone was saying, look out for that one. That was the stone-faced one. So it's an African-American male, middle-aged, and rarely took notes.
Charges against the defendant. 12 jurors must agree. So, all right. So I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous to reach an unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict.
She does this. She says the one in seat number 1 is the foreman, and then they find the alternates. It's I find it unreasonable that you do it that way. You always remove the alternates, because it should be a fair chance that there should be 12/18th of a chance for every juror. Now there's only 11/18th of a chance to be picked as a juror. That's math. And 12/18th is the same as
2/3.
2/3. And you have less than 2/3 of a chance if you remove 1. Depends on what mood I'm in. I like hindbærsnitter and pizza snegle the most.
Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own.
Even if they say Laurel.
No, Volstorm, because Sebastian is in Denmark and weed is illegal in Denmark, and none of us breaks the law. Who is giving physical descriptions of the juror? That was strictly forbidden. A middle-aged African-American man is not a physical description that you can ever use to determine which man it is, unless there's only one African-American in Massachusetts.
There's in Norfolk County, there's 37,000 and some change. Black.
Yeah.
You're going to say 37 false.
They talked about it during opening statements, during the opening of the case, because I believe Sue from Boston was describing it, and Aiden asked, is it okay? And he said, yes, as long as it's not more than approximate age and gender and race. That's more than fine, because there are more than one black person in America. I know this. I've just been to America. I saw at least two.
At least. The percentage of African Americans in Norfolk County is about half that of the rest of the country. FYI, I just looked it up. 7.24% African American, and the population of Norfolk County is roughly 520 something thousand. So it's like 37,000 African Americans in Norfolk County.
Okay.
Fun fact. There's your racism fact for the day.
It's not racism to.
It might be. I don't know. I think it is. I'm just saying it's racist, so that
let's ask Lefty. He's an expert.
Own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups?
I told you it was racist.
Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer.
Thank you, Tim Cox, for gifting Salty Dog in Indonesia a membership.
Nice.
Anyone else to answer any questions concerning anything material to the case. Generally, we will not take
Also weird when people try
answer
to
a question
scam
or
me.
take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case. I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought in to you and you can decide whether or not you want to stop
They
your
had
deliberations
lunch.
during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel at sidebar.
I doubt it.
Let's get to it. The jury has been sent out. Sadly, not at 2:23, but 2:39 is the time they left. Why is auto the lowest quality ever?
It's dumb.
Yeah. Oh, it went. Why did it skip forward?
Oh.
Mayor?
Yes.
Could the juror sitting in seat number 13 step down and take your place as an alternate? Could the juror sitting in seat number 7 step down and take your place as an alternate?
Well, this is different.
Juror 6, could you step down and take your place as an alternate?
Juror 6. Sorry. The others was by seat, and now it's juror 6.
Step down and take your place as an alternate. Could the juror sitting in seat number 7
Seat number
step down
7.
and take your place as an alternate? Juror 6, could you step down and take your place as an alternate? Juror 17, could you step down and take your place as an alternate?
Why is he mixing up seats?
Juror 2, could you step down and take your place as an alternate?
Yeah, why did you do that?
Juror 8, could you step down and take your place as an alternate?
Did he F up or?
All right. Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternate?
Jury 6 was the one everyone said, look out for juror number 6. So I don't know if it's good or bad.
Suffer them to disperse until
We
they
can't
discharge
read
the
minds.
verdict, except by further order of the court. So help you God. Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not...
Yeah, that's fine. Oh, there's arguments. Thank you, Holly Mac. The case started on April Fool's Day. Makes sense. It ends on Friday the 13th. I agree. Is there a mishap again with the verdict form? That could be perfect.
So the one exhibit, and Judge, the first thing is counsel this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150?
Yes, this is exhibit 155.
155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe that, my memory is not perfect, but I believe that we were going to have this redacted, subject to the same redactions from last trial. I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe it was redacted last time. So if the defense
Okay.
wants to make that redaction, you can go into evidence.
Great.
I'll see that a Sharpie and I can see here.
I think we probably have one here you can have.
I definitely have one somewhere.
There's one line in one piece of evidence that should have been redacted at the last trial, and they didn't redact it this time. Probably a name or an address or something. But again, how can they, 32 days into the second trial, still he doing that. And hey, Valkyrie, hope you get to go by the expert's house and get your gifts at some point. Send Valhalla over there. He's not doing anything anyway. He's just sitting there having intimate moments with his whoopee.
She has gifts at expert's house?
Yeah, I left gifts for her at the expert's house.
Oh, okay.
I told her that. I told you that.
I don't remember things. That's why they call me Valhalla 2 times.
All right.
That's number one. And number two is, can counsel look at the verdicts and just tell me if verdict slips and just tell me if they're okay with it? Thanks.
Isn't it
You'll see
kinda
that it's
too late
what you
to-
provided me yesterday, Mr. Kennedy.
Nah.
No, they took out the 6 alternates.
Yeah, ain't nobody going over to expert's house.
No, they made me sick.
Stop it. Stop
I blame the rabbit.
Stop it.
So no Friday Night Live tonight.
I haven't heard anything. I don't know.
How did closings go? Well, I think most of us gave the defense a B, B+, and the Commonwealth, it was Hank Brennan. Because it's such a long trial, so last time they lost 3, so they went with 18. Lies.
Baker got everybody sick, y'all. He brought, I don't know if he brought it all the way from Europe or if he picked it up in Chicago. I don't know what the hell the problem was. Maybe Finland. That's probably more like it. But he brought some nasty Danish flu with him and got everybody sick.
I'm a victim
of your own circumstance.
Yeah, she picked Foreman number 1 like last time.
Counsel, you can keep doing that. Mr. Rose, can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, that you not suffer any person to speak to them, to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse and to charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you.
I think the jury instructions were more clear this time. Last time she said you must agree on everything. This time she said you can fill out each slip as you go along. Karen looks angry.
I'd be angry if I was her.
Yeah, but why? And isn't it a little late?
I think that, well, Bev was supposed to show them, I think, the verdict forms before, and she didn't show them until now. And I mean, I'd be sweating like a me in church.
Yeah.
I mean, because, and if they went back with the same sort of verdict, form that they did the last time where they got all confused.
So, Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses. We really ran into the same issue last time. I think what complicates it is the fact that there are 2 theories for 2 of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti? I have not found any. I've looked.
It's a reasonable
There's not
thing.
a lot of case law out there in this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean,
So that's fine. So your rights are reserved. Does that help you?
No.
right, well, all we can do is object, Judge, and you make,
Okay.
you make the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know. Okay.
The last couple of things, judges, that we were provided with a clean computer laptop. Thanks. With a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right. So we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right. Thank you.
All rise for the court, please.
So they're going to run into the same problem they had last year, that the jury feel they must find her guilty on everything or not guilty. That's so again, the likelihood of a hung jury just went up.
And the likelihood of a confused, I mean, again, it's not so much is there case data. You ran into the exact same thing, Bev, last year. So don't you want to not confuse?
And how hard can it be? Charge one, did she willfully and intently unalive John O'Keefe? Guilty, not guilty. Good. Boom. Put that to one side. The next one had 5 different elements to it. Guilty, not guilty, guilty, not guilty, guilty, not guilty, guilty, not guilty, guilty, not guilty. And the last one, did she leave the scene of a crash? Guilty, not guilty. It's not that hard. And it's, let me say something that I know a lawyer don't like to hear, because lawyers are weird people. It's super intuitive and reasonable to do it in that way. Give them a dual option for each one. Chick-chack, chick-chack. Get out of here.
Yeah, because you better believe that if I got that, I would say, okay, we either, I guess, you know, I'd want a clarification that I'm not marking, you know, not guilty just to the first most, you know, charge that it was next to. I would probably write a note that says, hey, where are we supposed to mark not guilty for this and this and this?
Yeah.
All we have are those horrible sugar-free Gatorades. I'm not drinking that crap.
She's just setting herself up again for another hung jury and another. Again, she's been accused of so much. Why wouldn't you just make a simple little change? We see this in other cases. Every charge has a guilty, not guilty. That's the thing I just don't understand. And parents just don't understand.
Ooh, Will Smith rap. That a boy. Nope. That's my whoopee. I stole it from the expert's house. I'm kind of in the middle of something, babe. I can't go buy Gatorade right now.
I don't believe it. I know Lally said we will try again, but I can't see any way that they can justify spending probably $1 million, $1.5 million on making this circus one more time. Brennan is not coming back. Lally won't take it because the reason Brennan is there is no one wanted to take this case from the DA's office. So,
isn't he obligated though? Like, isn't somebody in the office?
They can force him to it, but they asked every DA at the office, and everyone said, oh, "Fuck no."
I don't blame him.
Yeah, well, 30 pieces of silver is 30 pieces of silver.
And when 30
And again,
pieces of
why
silver equate to $300,000, there's a lot more people willing to take it.
And again, why wouldn't they be able to go and start deliberating because the staff didn't have lunch? That was weird.
Yeah, I don't.
No, Morrissey is running for DA again.
He's not going to get beat. He's been in that position for how long now? Like 30 years?
25 years, I believe it is.
He's not. They're not going to oust him. I hope they do. He's a terrible human being and a corrupt politician that probably belongs in prison. But they're not going to get him out.
Just because the jury has now left the room and I have my tradition, we're going to talk about how long it's going to take. What will the jury find? 84% said not guilty, guilty of manslaughter, 13%, and guilty 1%. So it hasn't changed much since we started. 30 days ago, we had 3% guilty in my first vote. And now my always impossible poll.
Over here, we've got not guilty. Jury will find not guilty with 53%. Hung jury with 34%. 11% said guilty of man's laughter. And 0% said guilty of red rum.
All right. And over here, not guilty, 66. Hung jury, 29. Guilty, 3%. And manslaughter, 0.
Yeah, I think
is
now
there
that,
any bank holidays or whatever you call it?
Isn't Monday Juneteenth?
Is that a bank holiday now?
I think it's a federal holiday. I could be wrong.
I just because I was watching that coroner killer case, and they were talking about not coming back Monday. And I don't know, South Carolina doesn't strike me as the most Juneteenth state in the union.
That's not till June 19th is the day that we celebrate Juneteenth, which is next Thursday. I'm going to make a cake.
Brownies.
No comment.
Oh, that was good. That was hilarious, actually. Racist, but hilarious. Oh.
I don't think they deliberate over the weekend.
No. They'll go tonight, depending on how long they want to deliberate. They could go into the evening quite late, but then they'll break until Monday and come back Monday and start deliberations again. Yeah, generally speaking, when the verdict does come in, what they'll do is they'll present it to the judge. The judge will give everybody a half hour to be back in the courtroom. Then Twitter lights up and we all scramble to get back to our streaming platforms, and then they'll do it all like that.
It's 3:00 now. I haven't heard from the place I was supposed to be in 2 hours, so I don't know. Are we going to sit here? Are we going to... I don't think we'll have a verdict today.
I don't, just because they haven't even gotten, they're going to get in there and, probably just like, what the hell was that? What the hell was this? Kind of where we get to every day kind of vent, like, what the hell was that? They haven't gotten to do that until, just now. So I can imagine that a lot of the first hour is just going to be like, what the hell is what 4 persons supposed to do? I don't know.
Yeah. They want to come back. I really wanted to sit down and put my legs up.
You should get a whoopee.
Well,
whoopies are awesome.
I don't need a support blanket.
It's not a matter of need, sir. It's a matter of luxury.
Yeah.
Well, again, I don't know if I need to, because
Were there more words to that sentence, or was that it?
I was just looking in my DMs to see if I had a, and I haven't gotten an invite. So maybe it'll be here. I need to go destroy the throne and stretch my legs.
Well, what do we want to? What do we want to do here, y'all? Chat. What do we want to do?
We have that coroner case out of South Carolina where a coroner and her boyfriend, maybe unalived, her husband, boyfriend, someone else. I might not be quite sure on it. We can start that. I was thinking about catching up on it, just so we have something to hang out, talk about while we're waiting for whatever comes back. Should we do that?
I'm down, I guess. Sure.
Yeah, we can at least see the opening.
Okay, she was a body mover.
Ooh.
Well, as I learned through this case, I can move a body with center mass thrust. Yes, that was a sexual innuendo.
That a boy.
Well, I'm blocked by most of
detecting
them, so I can't really do those.
Last year, how many questions did we get last year? Like 3 separate questions from the jury?
Can we get something? And because they didn't ask in the correct way, she said no. And then we had 2 times they said we're hung.
Yeah, because then she had to read them the Alfonso. The whole.
Yeah,
What?
the Tui Rodriguez.
Yeah, that.
The Tui Rodriguez charge at the end there.
I was going to say it, the Limburger linguine, you know.
That's still wrong.
It was way wrong. But it was
At least
also.
sounds Italian, though.
It was also Bev, and I wasn't paying attention.
What do I have?
Brennan's closing has facts and substance. AJ was all over the place with his blabbering. Boring, hard to even follow. Jackson's close was full of sound and fury, signifying nothing. It was all for the free Karen reads. Brennan was marching through the timeline, the data, the evidence, and most importantly, Karen's own words. Can I see Grant Smith Ellis? Have you seen his screen setup?
The way he runs his streams?
Doesn't he have like 18 different points of view?
Yeah, it looks like schizophrenia personified is what it looks like.
Yeah. Oh, wait, but you also forgot that you have to hold your mic really, really, really close like this.
Talk really loud into it so it will overshoot all the time. I only get his fake account.
Are his fans called the washcloths or the towelettes?
No, it's the towels.
Towels.
Breaking news. We are now on verdict watch in the John O'Keefe and Karen Read retrial after Hank Brennan shocked the world by setting a new standard for American trial practicing during closing. Watch the towel juries live. Couldn't play it. Breaking news. The 4-person in the John O'Keefe and Karen Read retrial is the juror seated in seat number 1. Not breaking because that's every time. That's how
the way she does it. That's the way she does it every time, Grant.
This juror had the best view of Karen's face for the entire trial and very clearly showed disdain when Karen's clips were played. Oh, here we go.
Maybe they were showing disdain for the fact that Brennan was playing these out of context clips. Ever think of that? Douchebag.
Justin, deliberating jurors are now being seated in the John O'Keefe and Karen Reed retrial. Hank Brennan changed the game, and it's almost time. Justin, jurors are now being charged. Being charged? Why? In the John O'Keefe and Karen Reed retrial after Hank Brennan shocked the world by setting a new standard. We just had that.
Isn't his mom a lawyer? Like, could you?
Well, it's
I
Wendy
know
Murphy.
Mom's been doing this her whole life, but this guy knows how to actually get it done. This guy is setting the new precedent for what lawyers should be. What a douchebag.
Oh my word, per towel sources, initial reporting suggests that Paul O'Keefe had Aiden Teutelboy Carney thrown out of John O'Keefe and Karen Reed's retrial courtroom during closing arguments. It is unclear if this turtle walk is confirmed. How can it be unclear if it's confirmed? It must be really clear if it's confirmed or not confirmed. If it's unclear, then it's not confirmed. I will seek further information. John O'Keefe was not an it. John O'Keefe was not a body. John O'Keefe was not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed. Hank Brennan's closing in the John O'Keefe and Karen Reed trial is done. It was a thing of beauty. It was the greatest closing I have ever seen in an American trial. We are now 30 minutes lunch recess, and the jurors will change. This is how his screen looks.
Grant.
You should watch more trials.
Your prosecutor just compared him to not a buffalo in his final closing. You don't find anything wrong with that.
He's not right. Like,
what the hell? What? Remember, Dr. Russell, if Brennan asks you a question, make sure you ask for a transcript. Slow down the process. Interfere. What? Hank Brennan, I didn't know this was possible. You did it. You covered every witness for both sides. You wowed the world. Go get a whoopee and masturbate into that instead of sitting on Twitter. Listen, as long as you live, you will never see another closing argument like this. Hank Brennan has quite literally on a clinic during the John O'Keefe and Karen Reed retrial. Every fact, every witness, every damning defense lie memorialized. Isn't it? Oh, memorized. We are getting a special Hank cam for the closing on the John O'Keefe and Karen Reed retrial. This is the most unique possible. This is the most unique possible into a historic moment. What? Hank Brennan, you glorious man.
Gay.
I think it's because LG got thrown out of court yesterday, so now he needs someone new to simp to. Don't look at what Karen Reed did. Look the other way. Don't look the other way. Look at the facts. Look at the data. It leads to one person, the defendant. Hank Brennan, you're my hero. You used AJ's words. I'm building a statue for you.
Hank, I don't like you that much, but if Mr. Grant Smith Ellis gives you anything, I would just pitch it.
I'm not saying I'm normal, because I'm really, really not normal. Imagine if I ran my streams like this.
No. Is this why he thinks Dr. Russell's, PowerPoints are good? Because he watches this all day?
Memorized? He got Shannon's name wrong. Hey, Shannon with one N. Come on now. Yeah, and he called him Shannon Welcher. But imagine looking at this. I would need all the weed he smokes as well. No, because if I turn his stream on, he'll copyright strike me. Why is his logo all over it? Because then none of us evil people will steal his feed, because he has the special access feed to all the Zoom cameras.
Good.
But remember that case I was trying to cover where they had the Dutch angle on one of the cameras? I would lose my mind if I had to look at this. Well, yes, but Shannon was spelled with one N. And I have to agree with Farrell. Lefty's stream sucks. Well, Holly Mac, it's Grant Smith Ellis. Oh, can I see? No. Oh, he blocked me. What's going on? Can't remember his name. Yellow cottage cheese. Can I find that? Orksvold. That's his name. Is he saying something stupid? Well, he doesn't say anything else. No, he hasn't. No, I can't see anything. Love that they blocked me, all these bitches. Weak men. Today was the day that Karen Reed lost, and ironically, it happened because of an expert witness she was paying. Now the jury can envision the taillight shattering, how the holes in the shirt formed, and the debris field from the taillight. Meanwhile, Dr. Wolf, who the free Karen Reed world refers to as science, has his mock arrogance and credibility shattered. Science. No one calls him science, you fucking retard. We call him Crash Daddy. Science failed his first licensing test for accident reconstruction. Yeah, and Marie Hartnett failed her DNA proficiency test. He seemed to have trouble with sophomore math when presented with it by prosecutor Brennan several times. He just plain lied on the oath, and certainly the judge understood that. He never talked to his wife about Karen Reed. Lol. She's a member of the Free Karen Reed Facebook group. He only spoke with Jackson to arrange travel. We and the judge. No otherwise. No, you don't. You have no evidence, you fat, ugly piece of... Yesterday, people were asking me to predict what the results would be. I replied, hung jury. But that changed now, all because of Arca. A video is worth 10,000 words. Arca's video showed much, and all of it for the prosecution. Wow. Karen must have some sense of how grim her future is. If I was her, I would not pay Arca's bill. So you've got to get sued? Well, I don't think you ever paid a bill in your life, you rambling idiot.
I don't think you can... I think it's contract work and they've already paid.
I'm very jealous of Grant. Are you going to read the adventures of Stormwall and the fair maiden, Leva? Hello! Sadly, it's not legal in Denmark what they're on.
Yeah, but you think they'd be nicer in just wanting some granola bars. Or like Cheetos.
Well, let me see if I can find that South Carolina case. Half an hour has gone. Playlist. Is it on this one? No. Is it on this one? Yes. River dumping murder trial. The name alone says it's good.
Yeah, I mean...
Well, we have time, and we can do this because we're just gonna sit here anyways.
Pretty much.
And I'll put a
God,
banner
they have a
saying,
real life portrait of Matlock.
The river dumping case while verdict what?
Slidey pie. Not at this late juncture am I going to watch Yellow Cottage.
No. And again, they will probably copyright strike us. On October 5th, 2020, Megan Jackson reported that the father of her children, Gregory Rice, vanished. Rice's body was later found wrapped in a tarp along the Little PD River.
Oh, God.
Sue really wanted me to cover this case because it's the Little P River in November of 2020. Investigations revealed Jackson and the county's deputy coroner, Christopher Dontel, with whom Jackson was having an affair were allegedly involved in Rice's death. Dontel pled guilty in December 24 and agreed to testify against Jackson. That's already, I'll just say, that's a bad start for your case when your co-conspirators are already pled. So we can watch that while we are doing this. Who is this Justin? He keeps shouting out. Who? That's what Owl says. The little PD and the big PD. It glows under the 195. You look like you were sicker than I am. That whoopee has really sucked all the life out of you.
I was thinking about getting a bowl of ice cream. I have Rocky Road in the fridge. Are we doing our Friday beer?
Well, it's not. Stream isn't ending.
Okay.
Deny the motion because it doesn't require them to make any specific certification. However, under Brady, they have the affirmative duty to notify you of any deals or agreements with witnesses or anything of that.
Are they going to find a microphone?
Brady violation, but I don't know that I can make them go down each individual witness and say we don't have an agreement or we have an agreement to do. If there is an agreement, I have an affirmative duty to notify the defendant of that.
Your Honor, I can state that none of the law enforcement witnesses have any giglio issues. None of the civilians, most of them do not have any record whatsoever. One witness has a DUI from, I think, 30 years.
No, we're just waiting anyway. Ask away. We will most likely not be able to answer them, but you are always welcome to ask.
We'll give it our best shot.
Yeah.
Would be relevant to any sort of impeachment.
Oh.
I still believe if she's getting convicted, it's because of those video clips. Hey, Jamie, you heard little PD and then you came running.
Oh, how'd you know?
I was going to say, she didn't deny it. She didn't deny it.
Here I am.
Yeah. Defense lawyer in this case has a heavy accent. Well, I don't like accents.
Got a good accent? Good Southern accent? Come on.
2:39 is when they got out. No, none of that. No evidence of anything, and we don't even know that 1162-2 is when he was hit. It's just some random thing they said, well, it lines up. Because we went back and calculated all the evidence, and then now it makes sense.
And if we take out a couple of phone calls that we didn't quite track and do this, it matches up perfectly.
Yeah.
Matches up perfectly.
Yeah.
Yeah, look
Especially
how
with the
every
Tokyo
circle is
time
perfectly going along the way. Yeah, because it snaps it to a grid, you idiot. I'm going to go get my Friday beer, and I'm going to destroy a throne. I'm going to let this run.
And also the motion to exclude the physical evidence.
That means I need to take a dump.
We gathered, Baker.
We got it.
Now,
Appreciate the clarification.
Review the transcript.
There are no material errors in the transcript of the audio portion of the interview.
All right, what is your position on allowing the defendant to use the transcript
For impeachment purposes, but not to enter as an exhibit.
All right, we'll go with that then. All right.
Your Honor, the question of the letter, Detective Susi did bring the original letter with him this morning, the handwritten statement from Mr. Dontel.
Oh, okay.
I showed it to Mr. Preston Britton. I made another copy of it and also copied the bottom of the pages that he said were cut off. So I believe that we are fine on that.
All right.
And then, I'm sorry, one other issue, Your Honor.
That's fine.
There were several stipulations by and between counsel to chain witnesses. I have signed stipulations that were filed with the clerk of court. What the state would propose is that when it comes time, sort of in our order of witnesses.
Am I the only one that
stipulation
sees the
would be
Kool-Aid man
appropriate,
right now?
That I be allowed to read it into the record.
It's a lot of red.
It is a lot of red. What happened here?
No idea. Of course, it would happen when Baker's not here.
Yeah.
To
destroying
fix
the
it.
throne.
So I'll
I believe
sort
is
of
what
leave
it's
that to your discretion.
I'll leave it.
Oh, we're good. We're good.
Go first.
Oh,
Is
yeah,
any
never mind.
objections?
We're good.
One way or the other on that.
I think we would oppose that, Your Honor. I don't think we wanted an evidence.
And that's fine, I think, as I'm
As
thinking
long as
that
it's on the record.
it's on the record, and, yeah, I'm fine with that.
What in the frosted tips
Anything
is
further from the
going on here?
I don't believe so, Your Honor.
Anything
He looks
from
like
the-
Bradley Cooper.
Yes, sir. On the rule
I know.
615, we'd like to question the witnesses, Your Honor.
All right, any objections?
No, Your Honor, I do have a statutory victim in the courtroom. The other civilians are not testifying. Detective Susie is our law enforcement lead, and we would ask for.
Wait, Massachusetts gets a
sequestration of
room
any
the
kind.
size of
All right.
like a closet
So,
to do an actual case, and this room is empty.
All right, who's the lead investigator?
Detective Susie, Soucy.
Susie. Sinead O'Connor. That's
SOU.
CY, like saucy but with an O.
All right, and any victims?
Yes, Your Honor. Savannah Rice is present in the courtroom. She is the victim's daughter, oldest daughter.
All right, so Detective Susie, Savannah Rice, and the defendant will be allowed in the courtroom. All of the witnesses are sequestered. I'm leaving it up to the attorneys to make sure you do not have a witness in the courtroom, because I can't identify all of them, I don't know. So if there's a witness who's in the courtroom outside of these three, they're not going to be allowed to testify if they're in the court, okay?
Yes, sir. And Your Honor, we would also need, given that it's being televised, an order from the court instructing those who've been sequestered not to be watching this elsewhere.
Yeah, what we
That's
need
what
to do is
sequestered
make
me,
sure
bro.
there's- Where the jurors, I'm not the jurors, where the witnesses are going to be awaiting their testimony, don't allow any electronic.
Why is he trying to? Oh, don't adjust your crotch.
We'll have courthouse security monitor, make sure there's no electronics in there.
Okay, I'll tell you, we have a couple witnesses in the state anteroom right there, and I'll have our helpers, our assistants just advise witnesses not to watch the news or anything.
Well, no, I mean, I want to, because I've had this come up in past trials, no electronics, no phones, no computers, no TV sets, nothing in the witness waiting area, okay?
That's fine.
All right.
Thank you, Your Honor.
All right, anything else on the defense?
Yes, sir, Your Honor. There was one motion that we think we failed to mention yesterday, the court would hear it, just related to some physical evidence and picture evidence of guns, Your Honor. I think that'd be improper in this case. They don't have a murder weapon in this case, Your Honor. The defendant did own guns, but any effort to put those into evidence, we think is improper. I think it's improper effort to try to characterize the witness in a manner that is violates your constitutional rights to own guns.
All right, let's take.
It's a shooting death, and the guns that we intend to introduce are the same caliber as the bullets that killed Mr. Rice. They were submitted to SLED for examination. They are certainly relevant. We did not bring in every
SLED's
gun that
involved.
the defendant owns.
Yikes.
And quite
Roll
frankly, our
SLED.
information is that we don't have a murder weapon because she threw it in the intracoastal waterway. So the two guns that we have, that we intend to introduce, are the same caliber as the bullets that were recovered from Mr. Rice's body.
But what does the ballistic show? Were they the guns that fired the bullets?
The girl with the pink hair is the
What is
daughter,
the
Savannah.
relevance?
they were
To
talking
show
about.
that it's still part of the investigation because they saw
The oldest
guns
daughter
that
of the
matched the
victim.
caliber. They're submitted to SLED to determine whether or not they're the murder weapon, and they are not.
Well, then, what if it was a bazooka? The bazooka, but the bazooka wasn't used to kill the defendant because it's the same caliber. If it has been excluded as a murder weapon, then what is the relevance of putting the picture into evidence if for no other reason than to tell the juror?
Good call by the judge, though. If those guns are clearly not the murder weapon, all that is prejudicial.
Fair point. Why he didn't go with a rocket launcher, though?
He should have broke it down real good and just got an M249 machine gun. It was the machine gun I carried. I'm going to be honest. I'm liking this case less and less the further we get into it.
Yep. But it's always fun to see people who used to knock booties, you know.
So you're saying that
she's intense.
Every person that owns that caliber of gun would be a
scared?
Not unless they have the same motive that this defendant did.
Okay. Now, if you've got a picture of a gun that your testing has shown is not the murder weapon,
We have the actual gun is because the SLED examiner needs to look at that and say, he cannot testify that it's excluded unless he sees the actual gun and says, yes, I recognize this firearm. Here's the SLED lab number. Here are my initials. Here's the SLED item number. I looked, this is not the murder weapon.
Oh, I don't like her already.
I don't see how that's prejudicial if we're saying it's not.
Because it's not the murder weapon.
Because it's.
if I have a gun, it's not prejudicial for you to put it in, but it's not relevant either.
You're not the defendant.
I know, and I understand that, but what I'm saying is
She has crazy eyes.
I don't see the relevancy of putting in a picture of a firearm that is not involved in the crime.
So it's not relevant that we were able to exclude 2 guns as a murder weapon.
Why do you want the jury, are you going to put in every weapon that was excluded?
There were only 2 that were excluded because there were only 2 that were the same caliber. As I said, they did not seize every weapon that Ms. Jackson had. They only seized the weapons, and the only weapons that were submitted to SLED were ones that possibly could have been the murder weapon.
But ultimately were not.
Right, but that's part of the investigation.
Well, you can say that.
But the SLED analyst will not testify unless he sees the guns. They can't do it because they can't definitively say, this is the gun that I tested.
Well, they can testify that they did not test any guns that proved to be the murder weapon.
Right. We tested guns. They weren't the right guns. Easy peasy.
Sorry?
Also,
this is dumb already. The prosecutor's trying to get pictures of guns put into evidence that are not the murder weapon. Red rum weapon, my bad.
Oh, well, it happens.
Yeah.
Jess, it's very important that we judge on the facts, not the facials. Come on now. Are we clear for our Friday beer?
Oh,
Brandon?
You already got it in the cup and everything. Why are you doing that to me? Why are you doing that to me?
Yes, I was sending the baby to down the water slide.
Ew. Quit it. God.
I'll come back to you.
No.
Brennan has left the channel.
What? This damn.
Is Brendan ready or is he still crying?
I'm not ready. I'm not even close.
Hey, Kaiser. I don't know if it's
Hey,
crappy.
Kaiser. Crappy joke. Ha. Ha.
2 minutes. Well,
It's the actual gun. I have a photograph of the person who recovered it, but we have the actual guns. The SLED analyst doesn't look at a photograph and say, no, that's not the weapon. They look at the actual weapon. They test fire those weapons, and then they, yes.
Okay, I'm going to grant the motion to exclude the picture of the guns. I don't see the relevancy. there has to be a
Well,
relevance.
Judge.
And you have a firearm that is not part of the crime.
Well, Your Honor, you are substantially crippling the SLED witness's ability to testify.
That, why can't he testify? I tested the guns provided by police and none of them were the murder weapon.
Because that's not how, SLED has very exacting standards of how they testify. He needs to be able to say, yes, this is the weapon that I examined.
Yeah, but if you didn't examine the red rum tool, then it doesn't matter, you idiot. Hey, Valhalla, this wasn't the pen that I used to draw the peen on the face of the sleeping Brandon, but I will testify this is a pen, and it could have done it. So you have to find me guilty.
It is a pen, and it came from Baker's house. So
yeah,
everybody knows that.
Was Hank part of a twin set? Is this chick his sister from the same mister? Because
she's more attractive than Hank.
No, the prosecutor.
Oh.
Yeah, the prosecutor, not.
She's not attractive at all.
Well, that's why I was saying the prosecutor.
I messed that up.
And how is it legal to play interview clips out of context? Because you have your Miranda rights. Everything you say can and will be used against you. That's why the first word out of your mouth when the police says, it's late, you're arrested, you say, I want my lawyer. And you don't say anything else.
I don't think this mic has a mute button, which is unfortunate.
Well, there's a mute button right down in the lower part of the screen.
Yeah, but that's, requires coordination and
this would be like Hank bringing in a Toyota Camry from 2014 saying, it's not the same car. Well, he kind of did that with the bumper vault. She missing the forest for the trees. The SLED witness could testify none of the weapons recovered and tested was the weapon used. Well, they have a very exacting standard, MG. Come on now.
My initial reaction is that she knows exactly what she's doing. She knows that it's only prejudicial and she's doing it intentionally.
No, a prosecutor being dirty, I will not stand for that.
Especially when SLED's involved.
Yeah.
That's fine, but as I have said, we have the actual weapons that he testified and compared against the bullets.
Well, the basic premise is that evidence must be relevant to the case. And I don't see where a firearm that was excluded and is not part of the murder weapon, it's not part of the crime, it's not in any way associated with the death of the victim, is relevant in this case, other than to show that the defendant owned firearms.
No, it's to show that the investigators conducted a thorough investigation.
Well, you can do that without putting the gun in, saying, yes, we recovered guns. Yes, we found guns. We had them all tested. None of them were the murder.
Brandon is finally ready. So everyone, happy Friday. Fingers crossed for Karen Reed. And bottoms up and the rest in the hair.
Oh, that a boy.
No, you didn't miss it.
We just did it.
If it's not relevant, then it's not admissible.
Should be.
Brandon is a little behind. Apparently, someone gave all of them a disease.
Yeah, some foreign asshole.
I blame Jamie.
Uh-huh.
I was nowhere
The
near
person that
anybody.
wasn't there.
The Danish flu. I drank all those. Those are way gone, Paul. Those have been gone for like 3 days.
That woman is a blind date nightmare. She'll strong arm you for the bill. Most likely.
What team do you think she plays for? I'd be impressed if she was.
I didn't look at her till now. Oh my God, that face.
I'm telling you, she's scary. She's got
She's
crazy
scary
face.
looking. That's why I said she's got her eyes get bigger when she's yelling, and I'm afraid they're going to pop right out of her head.
Those annual services are just a money grab. Good. You didn't spill half of it like Valhalla did.
I didn't spill a drop. How dare you, sir? How dare you? Coming from the guy that had to get up and leave the camera shot the one time he attempted to shotgun a beer on stream.
I shotgunned the beer that you had shaked. I actually stayed seated and you left.
I didn't eat. No.
You need to go back and watch it. I'm not saying you were drunk, but I'm saying you were drunk.
I was drunk. That's not a secret.
And that is somehow less prejudicial.
Shizzy drove
than
my truck.
Showing a photo and the actual 2 guns that were tested and excluded.
Yeah.
So I can have an investigator say that they found 20 guns in her closet. They recovered 2, and those were not the murder weapons.
Exactly.
She's got a wedding ring.
I was trying to limit
You were trying to get in a physical thing to show to the jury that said this defendant owns guns. This is the same caliber as the one that killed the victim, so therefore the defendant must have killed the victim.
No, that's actually not what I was doing, Your Honor.
Oh, this judge I like.
MG, on a scale from 1 to really dumb, how smart is it to fight this with the judge right before he's going to be ruling on your case? Well, not ruling, but yeah.
We may not be lawyers, but we know the number 1 rule of litigation: don't piss off the judge.
I had to put a telephone book down.
And you probably should have turned down the music because you got a little... Val kept talking and I couldn't hear anything because of the music.
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
A thorough presentation, especially with SLED witnesses, is that we present them with everything that they examined. I have done this in innumerable trials, and there are plenty of times when it is not the murder weapon. I did it in the Samantha Raven trial where we had a gun that was recovered and it was not the murder weapon. It is part of the investigation. It's part of the res gestae of the investigation.
She's the prosecutor, yes.
You are crippling the SLED analyst's ability to testify because he needs to see what he actually examined.
I think he can testify without saying that whatever Horry County law enforcement brought the SLED for testing was not a murder weapon.
Okay, but if I understand Your Honor's ruling correctly, I can have my witnesses, which I was not going to, but now I will, testify that there were X number of guns in the defendant's home. They seized 2. Well,
Mo, is she wearing a pantsuit or a dress?
It's a little of both. I'm not entirely sure.
She has a weird, elongated body.
It's called a fupa.
Maybe she's pregnant, but if I have a little
Her
belly,
age, I don't think so.
I don't know that I would put
She's
a
just
belt.
a little thick.
No, but
is that what it is?
First of all, salmon, probably not her color.
It's
yes,
coral.
I said the L because I've learned from Valhalla you have to
That's not
pronounce.
salmon. That's coral.
It's salmon.
That's not.
But
it's not salmon. It's not salmon. It's coral.
It looks red.
it looks like her upper body stops here, and then she has a very long lower body.
Hold on, chat. We're gonna get a poll going.
She's pear-shaped and
It's salmon.
okay.
Salmon is pink.
Yeah, this is pink. Well, it
Not
looks
pink,
it's
of course.
it looks more orange on the feet, but it's more pink on the direct.
That's not salmon. All right, chat. The poll reads: what color is this lady's pantsuit? Salmon,
I think it's a
coral, or
dress.
other?
So it's a dress and a jacket. So it's a power kind of.
But with the belt there, it looks like she is 3/4 lower body.
I'm telling
People
you,
wear the
It's
high
an
belts
awkward
now. That's
place.
the thing.
It'll be like me wearing my pants above my fat belly. It doesn't look good.
But that's the new thing. Put a belt
Yeah,
like
why?
below your boobs.
Why?
Yeah,
I don't want
I
to
think
be
it's
held under
supposed
my
to be
boots.
umpire height, but she doesn't have a lot of boobage, so it's not accentuating the right thing.
It's accentuating something.
Well, just because you're all wrong doesn't make you right.
Seized 3, but they submitted 2 to SLED.
Right.
And those were not the murder weapons. So the state is not precluded from saying how many guns she actually had.
I don't know that they're.
What does it prove that she had many guns?
That's right.
I mean, what you're trying to do is paint the defendant's guilt based upon the fact that she owned guns.
I'm
And
not,
that
Your
the
Honor.
defendant was murdered
No, it's,
by shooting.
Your Honor.
I understand your argument. I made your number of investment on the photograph does not cover it.
Thank you, Your
All
Honor.
right.
This is day one.
And that's also physical evidence. The physical
Yikes.
evidence of guns as well, Your Honor.
What?
The physical, that's all, your ruling also extends to the physical.
I don't see the relevancy of a firearm that's not involved in the crime being relevant.
I like this, Judge.
Me too.
It was not the murder weapon. It was not fired. It was not used to kill the victim, and the defendant is on trial.
He makes
for murdering the
decisions
victim.
on the spot.
I don't see the relevance.
And they're good decisions.
Any firearm or any weapon
And
that is not. the
with
murder
that disclaimer so far, it's the first ruling I've seen.
Thank you, Your Honor.
All right.
I have had a chance to look at Detective Marcus's, presentation or report. If we'd like, I can hold off and make this argument later, so we can get started. If you'd like to hear from me, we discussed it yesterday. They provided me a report
It's a
of his,
presentation.
his presentation.
Oh, she's
of his
bitchy.
Cellbrite presentation.
All right. We hear from you.
Yeah,
Okay. So, Your Honor,
it's hard to boost because there are 3 different mics picking it up, but I can give it a little more boost.
Summarize the testimony and essentially present a closing statement through a witness. They're going to offer him as a digital forensics expert, from my understanding. And I can challenge those qualifications at a later time. But even if you accept the principle that he is a digital forensics expert, they have included in here things such as surveillance still shots from a restaurant. That has nothing to do with cell hawk data. That has nothing to do with GPS location data. That is a picture of a witness and a co-defendants eating dinner. They've added into this license plate readers. Well, Detective Marcus isn't an expert on license plate readers. It is a summation of the entire case in a packaged form, stamped with the name expert on it, to be presented to the jury. And it's just
So what
not.
are you asking?
I'm asking you not. I'm asking you
With
to
expert's
suppress
name
or
on
prevent
it.
her from showing demonstrative evidence that is outside the area of the expert, of his expertise. It could confuse and mislead the jury.
All right. What's the state's position?
Well, Your Honor, I don't believe it's stamped with expert, but what Sergeant Marcus does is he uses other items of evidence, which will already be in evidence, to validate the fact that, say, cell hawk, based on the longitude and latitude contained in the defendant's cell phone records, they say she was at point A. In order to validate that, so I am not just willy-nilly saying defendant was in point A, here is an LPR tag reader saying she passed by this area. Therefore, that helps validate that she was here. There's a picture of the defendant in Abuelos on her phone. There's geolocation data that shows that her phone is in that location. So it's going to validate the data that was provided to the defense long ago. Because I guarantee you that if we just had someone coming up and saying, cell phone data, how's her there? Well, how do you know? This is a way to validate the very records that we have provided.
All right. Anything in reply?
Yes, sir, Your Honor. Again, that's what makes it even extra dangerous. Because if it was just GPS, maybe I could understand that. But this is cell hawk data, which requires someone to testify who is an expert about how wide those ranges are. So on the one hand, they're saying that they're going to present evidence that shows a cone, a conical shape of where a person could be based on that cell phone data. And then they're going to show a picture to say, oh, look, they're together. And so that can mislead the jury to think every time there's a cell hawk ping, that means the two of them are in close proximity. But a wide range, Your Honor. So that makes it even more dangerous and more misleading to the jury.
All right. I'm going to deny the motion. I think the expert report is
Your Honor, just real quick. This goes to my point, which is, this isn't something I've had before. This is something I got yesterday. I do believe it is a report.
I've made my ruling. Now, that's the first thing I need to lay the groundwork. When the court makes a ruling, that's the end of the arguments. Don't keep arguing your position.
Yes, sir, Your Honor.
All right? Anything else?
Yes, sir.
All right.
Oh, wait.
All right, let's bring the jury. Okay, hold for a second. Tell them to hold up.
Luke, stand up.
I think we got another.
Everyone, I'm gonna jump off for a bit. I promised Kurt that I would stop by and talk to him today. Mo will be running the show while I'm away. 2218.
To make sure you do not have a witness.
If verdict, but if anything happens in court, Mo will make sure that even I'm gonna go say hi to Kurt, and then I think I can leave the studio and it still will run. I hope so.
Yeah, you'll be fine.
I think so.
If you're sharing it and you leave studio, then it'll close out. But most sharing it, it'll be fine.
Okay.
We should be.
I got you.
Yeah, I'll be gone for a little while, and stick around. Show Mo and Valhalla a little love while you're here. And Jamie.
Don't forget about Jamie. Oh, before you leave, Baker. Real quick, before you leave, what color is this lady's pantsuit? 6% said other, 25% said salmon, and 69% said coral. 69, Baker. 69.
Giggity.
Giggity.
All right. That was all. You can go now.
Thank you.
Deuces.
Okay.
It's just us. It's just you and me.
Just
and,
the
me and the
three of
ladies.
us.
We can
Alrighty.
make it if we try. Anyway.
Take notes, so I'm going to allow them to take notes, but I give them some instructions on note taking.
I have it boosted up as loud. Hopefully they use microphones.
What happened?
Well, I was
You're just
hearing.
bringing the jury in, right?
Yeah. Well, and then the closed captions started going, so.
Great assistance to the court. I want to thank you for being on time, and I apologize for keeping you in the jury room for so long. Now, we are getting ready to start the trial of the case of the state of South Carolina versus Megan Marie Jackson. I've got some preliminary charges I need to give you before.
That's as boosted as you can get it?
That's as boosted as I can get it.
I understand Mr. Roberts, you've been selected as foreperson, is that correct? Yes, sir. All right, thank you for serving that.
It's not the worst thing in the world.
Occupy the seat that you now sit.
We can't pull those up, though.
You can always occupy the alternate seats unless you
Oh, yeah, we can't pull up super chats.
We can't pull up super chats. Lesko says they call her Thunder Cunt. That checks out. I believe it.
As I also told you during jury qualifications and during voir dire, jurors, just like witnesses, are constantly taking oaths. So I'll need all members of the jury to please stand and raise your right hand while the clerk administers the oath for you as jurors on this case.
It does sound like they forgot to turn the mic
You
on.
will affirm you will well and truly try the issues joined in this case and a true verdict rendered according to the law and evidence, so help you God. Thank you. You may be seated.
All right, is there any member of the jury that did not respond to the oath by saying I do or yes? If so, please stand. Thank you very much, ladies and gentlemen. Now, we're getting ready to start the trial of the case of the state of South Carolina versus Megan Marie Jackson. Now, I know from watching TV shows, movies, reading books, things for entertainment, trials are usually full of a lot of suspense, a lot of action. While that might be the case in this trial,
She looks
that probably
terrified.
won't be. I think what you're going to find is that trials are
She
often
looks
slow,
sympathetic to me.
process.
Oh no, she's definitely going to prison.
Opposite of what you might be accustomed
Definitely.
to when you read about trials or watch trials for entertainment purposes. But I hope you do find the trial entertaining. I hope you find it educational. And I want to thank you from the outset for serving as jurors on this case. The attorneys appearing before you are advocates for the parties they represent, but first and foremost, they are officers of the court. They're sworn to uphold the integrity and the fairness of our judicial system and to help you in the search for the truth. You should expect them to be professional, competent, and ethical in the representation of their client's interests. What I now say to you is intended to serve as an introduction to the trial of this case. These remarks are not a charge on the law of this case. I'll instruct you on the law applicable to this case at the end of the trial before you.
All right. Do you want to just skip to the opening statements, or do you want to hear kindly old lawyer or judge who we can barely hear?
Let's just listen, because I don't know what exactly what the charges are or anything even.
Sounds
We got
good.
time to
I
kill,
am going
though.
to mute
It's not like we're
myself
in a
because
rush.
my feral children are home.
Fair. It's not like we're going anywhere. It's not like we're in a rush or anything. We got time. We got time. We can listen to old man's meandering.
To consider your verdict. This is merely an explanation of the procedure that we will follow in the trial of this case so that you can better understand what might be happening. Now, the defendant is charged by 2 indictments. One charging the defendant with murder and one charging the defendant with criminal conspiracy to commit murder. Now, I'll explain the elements of those crimes to you. at a later
Chat's saying
time.
skip.
What you
John
need to
Gary
know
says
now,
skip.
though,
Jedi
is that
Just
these
says skip.
indictments are simply the charges by which this case is brought into this court.
Okay,
They are
then.
not in any sense evidence of any of the allegations contained.
I do want to remind you that we're going straight to Crazy Eyes if we skip the kindly old judge. Oh, I
That's
guess
true.
we've got a different blonde.
Well, she looks way less insane.
May I please the court, Your Honor?
Yes, ma'am.
She's got the old Jackie O thing going on, huh?
This week, you're going to hear facts and evidence in this case. And those facts and evidence are going to tell a story. And it's going to be a familiar story because it's a tale that's almost...
The charge is essentially the ending of the life of her husband. I don't know the exact charges, but she's accused of red rumming her husband, the father of Savannah.
I think it's...
murder and conspiracy to commit.
Yeah, so... All right.
The victim of that murder is Gregory Rice, the defendant's the father of 4 of her children. And when you look at the facts and evidence...
That girl's had
events
more than
that
4
you're about to
kids?
see, there's one person who connects all of those things. There's one person at the center of everything you're going to hear. And that person is Bailey Jackson. She's sitting right over there. Now, when you look at Bailey Jackson, you may think, she looks meek, mild, she's a small woman. But looks can be deceiving. And this defendant is certainly deceiving. She deceived Greg Rice. She deceived her co-defendant, Christopher Dontel. She deceived Christopher Dontel's wife, Erica Dontel. And she deceived law enforcement. So as you're watching this, make no mistake. The defendant may look like a victim or portray herself that way. She may look meek and mild, but she is a master manipulator. And that's what she did in this case. And not only is she a master manipulator, she was literally in the business of death. Her job back in 2020 when this occurred was as a body transport person, a body mover. So what she would do, she worked for a company that whenever someone died of natural causes, or if it was a homicide or even a gruesome accident, she would respond in her van and she would pick up the body and she would take it wherever it needed to go. So that's what she did. And in the course of that job and that employment, she met a man named Christopher Dontel. Christopher Dontel was also in the business of death. Before she got the job as the body transport business person, that's what he did. And he trained her. And then he became a deputy coroner, and it was his job, much like Megan, to respond to these scenes of death and to fill out paperwork and to perform the duties of the coroner. In the course of that employment, Megan Jackson and Christopher Dontel saw one another very often, and they became close. Now, Christopher Dontel at the time he had a pretty good life, a pretty normal, I would say, everyday life. He worked as a deputy coroner. He was married to a school teacher. Community, and at the same time, Megan Jackson had been in a relationship with Gregory Rice, the victim in this case. They shared 4 kids. About approximately a year before this murder occurred, she and Gregory Rice broke up. They were no longer together, but they were kind of always connected because they shared these 4 kids. You know, if you share kids, you're going to always have to talk to someone. They would speak about the kids, they would text and call, and that's really what their communications were about. So after Megan broke up with Greg, she pretty quickly moved on to Christopher Dontel. She set her sights on him, and she basically infiltrated his life. She literally bought a house in the same neighborhood right down the street from him. She befriended his wife. She befriended his kids. She started buying the family expensive gifts with an inheritance she had gotten and made promises of more. She spent her days hanging out with his wife and Christopher Dontel. She became, in a large part, a third party in their marriage. And because Christopher Dontel and Megan Jackson were kind of dealing in death, they were doing this job where they were transporting bodies and responding to these scenes, they had a reason to be out at all hours of the day or night without anyone raising any suspicions with anyone. They could be together, they could be out all night, they could spend the night, he could spend the night at her house, and no one thought anything. She actually started an affair with Dontel and conducted that affair right under his wife's nose. She was hiding in plain sight, and she was deceiving everyone. So around, I'll say September 2020, a couple of things happened that kind of changed things. The first thing that happened is Megan Jackson got pregnant with Christopher Dontel's child. At the same time, someone anonymously began exposing the affair between Megan Jackson and Christopher Dontel to Erica Dontel, his wife, through texts and emails that kind of had pictures and statements about what had been going on. That was done anonymously, but Megan Jackson represented to Dontel that Greg Rice was responsible for those things. Now, the judge said that you're the judge of the facts, and I'm going to ask you, as you're watching the facts
his wife and
evidence
then
presented
sleep with
in
her
the
husband.
courtroom,
Like,
ask
come on,
yourself, who had the
Yeah.
biggest motive to blow up Christopher Dontel's marriage? Ask yourself that question. So that was going on, and then on October 2nd, 2020, Gregory Rice disappeared. A Friday night, he just disappeared. And Megan Jackson began acting very quickly to divert suspicion away from herself. That weekend, she had an officer do a welfare check on Gregory Rice. She showed up at his house when normally she would make him come pick up the kids. That Monday morning, she showed up at the police department, filed a missing persons report, and in the course of filing that report, she tried to portray Greg as some degenerate drug user, which was the furthest thing from the truth. He basically went to work, took care of his kids, and stayed home. He was a homebody. So she was trying to divert suspicion. But
Ma'am, stop playing with your lips and don't
What's
roll your
happening?
eyes.
What's she
like
doing?
you hate your husband, the father of your children who is dead. Don't roll your eyes and act like you're in family court, because you're not, and he's still dead, and you don't want to look like a heifer. She's like,
Let's go.
I
Let's go. Brandon says, that's a huge female dog. That's a
Yeah.
huge bitch. From
She does not like her saying anything nice about her ex. This is going to get really, really bad really quick.
Okay, so as far as I understand it, this woman somehow has had 4 kids with her man, started an affair, got knocked up by that guy with her 5th child. That guy, I think, is the co-defendant. I could be wrong on
Yes.
that. Don't lock me into that answer. And the father of her 4 other kids is perished, no longer with us.
Yes.
No, not Nutty Pretty. It was from Deuce Bigelow, Male Gigolo. That's a huge bitch. Yeah.
An entire movie where Rod Schneider is a sex symbol. The
I'm here
odds
for it.
were a crazy time.
It, it boosted Baker's self confidence, self image, ego. What's the word I'm looking for?
Ego.
What's the
Self-esteem.
anyway? That's the word. Boosted Baker's self-esteem. That it would have been better if I didn't fumble.
It's okay. Let's continue to watch her chew her face off.
She's got facial expressions
Police began
like
looking for Gregory Rice, and they do what
who's
police
the one
do. They
chick?
start looking first at people closest to him. So they look at
She
Megan
business?
Jackson. They just say quickly that she's having an affair with Christopher Dontel. The other thing that police start doing when they're looking for someone is they start looking at cell phone records. I'm sure, although I know you're not allowed to have them now, that
Not in
almost
Canton.
everyone here has a cell phone, and you pretty much take it with you everywhere you go. I know I do. And when your cell phone, when you make a call or you get a text, or sometimes when your phone's just running an app in the background or doing something, it connects to the cellular network and it hits these towers that are located around the county. There's one pretty close to the courthouse you may have seen. And based on those kind of cell phone records, police can identify the approximate location of people, where they are. They can kind of track movements that way. So police began looking at Gregory Rice's cell phone records. And one of the most striking things they noticed is the last person that he spoke to the night he
$20 says
disappeared,
Legally
October
Blonde's
2nd,
on one of her top 3 movie lists.
was Megan Jackson. Police also start looking to see where Greg was. So once they realize that Megan Jackson's having this affair, that she's the last person to speak to Greg Rice on the phone, or it looks like that's the last phone call weekend, suspicion falls on her and Christopher Dontel pretty quickly. The last phone call weekend, suspicion falls on her and Christopher Dontel pretty quickly. But nobody knows where Greg Rice is. So they haven't found him. Now, police know the longer Greg is missing, the less likely they are to find him alive. So as time passes, police begin to suspect strongly that Greg Rice is dead. And lo and behold, about a month after he goes missing, Donna Sue Souls was setting catfish lines in the Little PD River.
I thought she was
Anne Catherine Boyson, question for Mo or Valhalla. What is this for an accent or region she speaks? This is Southern.
South Carolina.
South Carolina.
She's down there in the what do they call it? The
Low
bottom?
country.
The low country. There you go. She's down there in the low country for sure.
Yeah.
South Carolina get real southern sounding sometimes.
I'm just like, how cliche could she be? She's blonde, she has pearls on, and she's wearing a Jackie O suit.
She
I love it.
I'm here for it. I'm not gonna lie. I'm here for it.
I know, it's kind of comforting after Soror and Lavarer. And
I love the South Carolina
Lar.
accent. It's something,
Lar.
it's different than
Yes.
most. So,
and
Sue
it's
says
much
it's
more
Myrtle Beach
pleasing.
area. Myrtle Beach.
It's more pleasing to the ear than sorrel and idea.
Way better than that weird Fall River accent.
It is weird.
For those of you who don't know, that's the geographical border between Horry and Horry and Marion County. They were setting catfish lines in the middle of the night. They happened upon the body of Greg Rice.
setting catfish
Greg had been
lines.
shot.
Stop
I
it.
thought it was a metaphor
He
at
had
first,
been
and then I
wrapped in a
realized, no, he
tarp
was actually out there
that
setting
was
catfish
zip
lines.
tied.
Okay.
Someone had taken ratchet straps and wrapped around it and weighted it down with cinder blocks to try to, and dumped him in the river. So that's a big break in the case for police. It also gives them a new lead to follow. That lead is they start looking at the tarp and the cinder blocks and all these items that Greg's wrapped in, and they start going to stores around Horry County to see if any store sells those items in particular, because those items have tags on them. So they end up going to Lowe's Home Improvement, which is a national chain, I'm sure you all know, and they speak to the security officer.
Are
was at
both
Lowe's
of these
yesterday.
two there's are both of these her children?
I know the
Because
girl
they-
in the pink is. I'm not sure who the other one is. Could be.
Well-
Kind of have a similar appearance.
Well, I was thinking, weren't there 4 children with the Greg, and then
Yes.
the 5th baby was with Donatello, Chris Donatello,
There was at least
Donatello.
a 5th pregnancy. I don't know if it happened to end in child.
I didn't think she
Yeah.
actually had any kids with him.
Oh, I
have no idea. I haven't been.
this is going to
upkeeping-
be hard to watch with her, because she's already.
Wait till she takes
Yeah.
the stand. Yee.
Oh,
Yeah.
She was yelling, there's no 5th baby.
No
Oh.
5th baby.
Okay.
There you go.
oh, all right. No, I think one is a man. The one with brown hair is a man, I think. Danny T.
Pretty sure. I don't know.
I mean, that's a pretty heavy beard growth for a woman.
Nah, I've seen worse.
Well, I mean, fair point. Let's continue.
And he starts looking at receipts. And then he finds a receipt from October 3rd, the day after the murder.
She
where a
made up
person
the 5th
called
baby.
all of those items together, and I think a Pepsi Zero. So he goes and he says, that's a rather suspicious shopping list. It's basically a murder dump kit. So he goes and looks at surveillance footage, and he
Would you be shocked
finds
for how the
Christopher
live
Dontel
pregnancy-
pushing a shopping cart through the Lowe's checkout line with a cart with a tarp, zip ties, cinder blocks, and ratchet straps. And that
You should
leads
try to buy
police.
those in
They
multiple
start
stores,
looking
ladies.
for surveillance video. They know the body was dumped.
Yeah,
Don't buy your whole murder kit in one store. Just the general.
No, this is why you
word
have to buy it in stages. It's like how you Christmas shop. You buy one piece in, February, one piece in January, one piece in, November.
Terrible. Terrible. That's like that scene in Breaking Bad when Walter White walks up to the guy and he's like, "Don't buy all your meth stuff in one store. Spread it across town a little bit." It's got
I've never
everything you
watched
need to
that.
make. Oh, it's an amazing show. He walks up to this meth head who's got literally everything you need to make meth in a shopping cart. And he's like, "Maybe you should spread it around a little bit, buddy."
I was pissed off that because of those people, I had to wait until some very disinterested Walmart person made their way up to the checkout so I could buy my Mucinex this morning.
Yes, Stringer Bell, we are on verdict watch. We are tuned into the river dumping murder trial of South Carolina
Yes.
versus Megan Jackson. In the meantime, we've been on verdict for nearly an hour and a half, an hour and 26 minutes. I've got
Yes.
the court feed up. Not that we can change it or anything if it does start to happen, but I will get Baker's attention when the time comes, if the time comes.
Sounds good.
in the Little PG River. So they start looking for routes you would take to get there from kind of this area, the beach area where Christopher Dontel lived. And they find surveillance footage from a convenience store, Little PD Exchange, showing Christopher Dontel going back and forth to the dump site in his county vehicle. At
Exactly,
the same time,
John.
of course,
You bought the wrong kind of
suspicion
matches.
has already fallen on Christopher Dontel and Megan Jackson. But at that time, police start looking a little closer. And they start looking at cell phone records, any surveillance they can get. They look at license plate readers. And for those of you who don't know, license plate readers are cameras. A lot of municipalities have them, and Myrtle Beach has some out on the highways that the cameras capture the license plate of your car as you pass by. So you can tell where cars are on the highway sometimes by looking at these license plate readers. So police start looking at cell phone records, surveillance, and license plate reader to track the movements of Megan Jackson, Christopher Dontel, and Gregory Rice. And what do they discover? Well, the most striking and obvious thing police discover is that Megan Jackson and Christopher Dontel were together the entire night of October 2nd, the night that Greg went missing. They left, they met up about 6:30 in the evening at the Lewis Ocean Bay Heritage Preserve. That's just a wildlife management area where you can go, you can see endangered plant species or walk around and look at nature. But what they were there for, police found out later, was target practice. They were actually shooting guns. Megan liked to shoot, so that's what they were there doing that day that Greg was murdered. They left there, they went to Abuelo's, which is a restaurant, Coastal Grand Mall, you may have seen it. They're on surveillance camera there eating for about an hour. They leave around 8, and then they come back. Christopher Dontel comes back about an hour later, about 9 o'clock, to use the bathroom. He tells police that in that hour they were driving around conducting their affair, that he was receiving oral sex from Megan, that's what they did when they were together.
Giggity.
An hour?
She's got a strong jaw, Mo. She's got a strong jaw.
What do you say? This is the river dumping case where it seems like one deputy medical examiner and one body mover had an affair and tried to unalive her baby daddy, but got caught like right away.
Why wouldn't they have just cremated him? It's
Yeah,
crazy
why
to me.
wouldn't you have, I mean, come on, it's not like you don't, okay. Yeah, why you could have cremated him. No one's gonna know.
They're gonna know. No one's gonna know.
And that face is not looking the kindest and the most innocent-y, but
No,
Yeah,
the
but
guy,
he said-
the co-defendant's already pled out, I guess, and he's
yeah, so he's going to be testifying against her too. These are opening statements. And apparently they bought the entire red rum kit at like Lowe's at the
Lowe's
same
Home
time, as you do.
They eventually end up at Myrtle Beach Funeral Home. Now, Myrtle Beach Funeral Home is a funeral home. It's on the bypass over near Market Common. You probably know where that is. It's basically a crematorium. Megan Jackson and Christopher Dontel had access to that funeral home because of their jobs. The county sometimes would store bodies in the coolers there if there were just not enough room at the coroner's office. So they were there, and their cell phone records put them there. Around 9:45, Megan Jackson calls Greg Rice. And these are approximate times. Around 10 o'clock, she calls him a second time. At the same time, her body transport van, the one that she uses for work when she's doing her job as a body mover, is seen entering the homeowners associations, entering the gate of Arrowhead community where Greg lived. It captured on
Valhalla, are you seeing any movement in the court?
there's nothing on the feed so far. It's still got Ceiling Dion up there. Nothing.
Well, let me
Nothing.
open up another window Oh, I was about to say, I'll just go to Baker's feed. And I'm like, no, ding dong. Baker's not covering this right now.
Someone says jury question. So
Yeah.
I've got the
let
court
me
feed
just-
open. It hasn't. They haven't said anything. They haven't changed anything.
Oh.
Twitter, I bet, would be the
You gotta
best
be
source of
careful.
information.
Yeah.
Yeah, Twitter's the best place to go to look and see.
Yeah, Twitter is a whole lot of crazy.
On the Homeowners Association's license plate reader. She goes in there, or her van goes in there. It stays 6 or 7 minutes and then out. At the same time, from 5 o'clock to 10 o'clock that night, Greg Rice's phone is hitting off the tower near his apartment right there at Arrowhead at Flint Lake Apartments. So it doesn't look like he's moving, it looks like he's home. But around 10, the same time Megan Jackson's van shows up in his neighborhood, his phone starts moving. And what his phone does is it travels to
I'm
the
keeping an
Myrtle Beach
eye on
Funeral
it too, so
Home. At
when
the same
it
time
actually
it's traveling,
does
Megan
come
Jackson's
in.
van is traveling toward the Myrtle Beach Funeral Home, hitting license plate readers along the highway, the major highways in Myrtle Beach. So Greg's phone and Megan's van go back to Myrtle Beach Funeral Home. Now Greg's phone stays there a little while and makes some data connections. So I told you before, whenever you use your phone, sometimes you're making calls or texts, and that's a user-initiated action that causes your phone to connect. But sometimes your phone connects.
Y'all, this is the feed on the courtroom. So I'm not ignoring you. I'm watching just like y'all are. But let me.
Oh, you can switch your screen. We can do it. Cool.
Well, so
Cool.
yeah, if you have it on the same
Yeah.
server
I didn't
tab.
think it through. Okay, so we can pull it up even, chat. We got this.
Yeah.
All right.
So
Go back to the other thing. I'm watching that screen. If anything happens in court, we will be on top of it.
wait, are they saying verdict? Let's go. If you're messing with me, I'm too far gone on my
Don't
Mucinex.
even listen to him if he's
Yeah,
saying
you're making a mistake already.
All right.
Without you doing anything. It can have something running in the background or some app that uses cellular data and it'll connect without the user actually doing anything. So just because Greg's phone is connecting does not mean that he's alive, it just means that his phone is there. So eventually, Christopher Dontel and Megan Jackson, you can see from phone records and LPR, start traveling towards the Lowe's Food on International Drive. That's an important location for them. That's where they would go to leave cars so that they could conduct their affair, so that there was just a place to leave the car, essentially. It's kind of close to the neighborhood. It's right by the Lewis Ocean Bay Heritage Preserve, where they were going for target practice. And around 11 o'clock at night, a computer store in that shopping center captures Megan Jackson and Christopher Dontel on camera. Christopher Dontel has a bag, Megan Jackson's there. Importantly, at the same time, Greg Rice's phone makes a data connection to a tower that would put him in the same vicinity, around 11 o'clock, a little after 11 o'clock that night. That's the last time Greg's phone ever made any connection with the tower. After that, it's just gone. So that's the last time Greg Rice's phone makes a connection. After that, Megan Jackson, we learned later that Greg Rice was in the cooler at the Myrtle Beach Funeral Home, his body. After that, Megan Jackson and Christopher Dontel go back to the Myrtle Beach Funeral Home to get they were getting belongings so that she could put some of those belongings to set up this welfare check that she did the next day to make it look like he had wandered off an OD. So they went back to get that. But something else happened that's a bit unusual. When they got there, around 12:45 that night, there was a trade-in bomber there. And as I said, everyone in this case is kind of in the business of death. The trade-in bomber, because Myrtle Beach Funeral Home doesn't have a full-time embalmer, they mostly cremate bodies. The trade-in bomber would
Okay, how does one become a part-time embalmer? Because I have a question. And You guys, this is what we're currently getting on this. So as soon as it switches over,
Don't worry about it. Don't worry about it. If something happens, we're gonna pull it up, you guys. I've got it live. I'm watching it. I'm listening to it. Mo's got it live. If something happens in court, we will bring it up. Promise. Promise.
you know, it's them just asking so they can go home because it's past 4
Guarantee it.
on a Friday.
Guarantee it. They're gonna be like, let's just go home.
Would come on a contract basis and in bond bodies. And he did that kind of whenever it's convenient for him. You'll hear from him. So he was there at 12:45 a.m. that night. He was there in the middle of the night embalming a body. So when Christopher Dontel and Megan Jackson showed up, he saw them there. And he'll tell you that. He saw Christopher Dontel there. And they left. They stayed together, kind of, you'll see on tape, they're kind of going back and forth. And then finally, they spend the night together, and then around 8:15 the next morning, they go back to Lowe's Food, and they get in their cars and go their separate ways. So, back in December of this year, that's kind of what law enforcement knew about this case. And much like we did here today, Ms. Walter and I, the state of South Carolina, we called Christopher Dontel's case to trial. Just like we did today. We picked a jury, the same thing. We went through everything. And then as I was sitting in my chair, getting ready to stand up, Christopher Dontel shocked everyone by standing up himself and voluntarily pleading guilty to accessory after the fact of murder with no agreement with the state.
Well, that was dumb.
That was also allowed law enforcement to fill in some blanks. Christopher Dontel, after he did that, agreed to speak to law enforcement to kind of fill in a lot of missing pieces of this puzzle. You're going to hear from Christopher Dontel. He's going to testify. I have no doubt that Megan Jackson's attorneys will make a big deal out of the fact that Christopher Dontel has a motive to minimize his conduct and point the finger at Megan Jackson. The judge has already told you. You, the jury, can decide what to believe, whether you believe some of what he says or all of it. He's going to tell you that that night,
What are you doing? You're muted.
It still continues to be the fan.
Yeah.
So they might
Don't
be,
listen to chat,
you know,
Mo. Stop listening to the chat.
I'm just letting people know because, you know,
They'll
Baker
figure it out.
wants to come back to, you know, have all the people. He's going to be like, I was told you didn't switch over to the actual child that we were looking
There's
at.
nothing happening in the Karen Reed courtroom. Nothing. Nothing. I'm gonna yell at you, Chad. Knock it off. You're messing with Mo. Stop it.
Christopher Dontel and Megan Jackson took that body transport van into Arrowhead when it hit that license plate reader. And they went in there, and Megan Jackson called Greg, and when he came walking up to the car, she got out and shot him and killed him. And the two of them hustled out of that van and put him on their body transport stretcher, and they threw him in the back and went back to Myrtle Beach Funeral Home, where they put him in the cooler while they decided what to do.
Why wouldn't they have just put him in the
All of that
crematorium?
testimony matches.
Why wouldn't they have just cremated him
what law
right then?
enforcement already knew. There's nothing
No
that
idea.
he's
This
saying
makes
to
no
us
sense.
that is not borne out by those cell phone records, surveillance records, and LPR records. You'll see then too, the next day is when he goes and buys this body dump kit and takes the body, dumps Greg Rice in the Little Petey River. So you decide what to believe in this case. You decide who you think is responsible for the murder of Gregory Rice. Gregory Rice, and you're going to hear from Christopher Dontel, you're going to see Megan Jackson sitting over there. The only thing Christopher Dontel and Gregory Rice have in common is Megan Jackson, who's sitting right over there. That's the only thing. The judge is going to instruct you on the law at the end of this case. He's going to tell you about conspiracy. That's just what
He
it
looks less
sounds like.
terrified
Two
and
people
more
get
angry
together to
now.
commit a crime. He's gonna give you the
Yeah,
definition
or
of murder.
constipated.
In South Carolina, we don't have degrees of murder. We have one definition, and that definition is, it's the killing, intentional killing of another person with malice aforethought. None of you guys need that definition to know that shooting someone, wrapping them up in a tarp, and weighing them down with cinder blocks and throwing them in the river is murder. But what you do need to know about South Carolina is South Carolina has something called the hand of one is the hand of all. I'm going to read you what that means. This is the legal definition. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act of all, or as it's sometimes said, the hand of one is the hand of all. Two people can be guilty of killing another person when only one of the two had a gun.
Oh, I don't like those glasses
There
at
was
all.
only one bullet, and only one of the two fired the shot that caused the death.
You know, I kind of like them.
So what I'm asking you to do is, if at the end of this case, which
But it's like that in between where I don't know if I really love this or really hate it.
Could go either way.
Yeah.
Okay. I see you.
I don't know with that outfit because I think that she should have picked a solid one.
Bye, Jamie. Love you.
Bye.
Bye, guys. Have a good weekend.
You too. She gone, y'all. She gone.
She gone.
And maybe it's just her face. Maybe it's not a good frame for her face. I don't know. I don't like it. Stands out too much. Looks weird.
It's really busy for her.
She's got a lot going
clear
on.
and obvious who's responsible for the death and for the murder of Gregory Rice. And at the end of this case, if you believe that Christopher Dontel and Megan Jackson are responsible for the murder of Gregory Rice, then there's only one verdict, and that's guilty.
Pretty clear and obvious isn't the same as proven without a reasonable doubt, though.
Also, why am I just hearing the white rabbit?
I'll be honest with you, I thought she was going to say Dontel at the end there, because that's what it sounded like, right? That at the end of all that, Dontel was the one, the hand. Ladies and gentlemen, my name's Case Brennan, and I don't want to talk at you guys. I really do my best not to talk at you guys. I'm here with my father, Tommy Brennan. I'm here with my younger brother. He hates it when I say that, Preston Brennan. I'll be...
Okay, why couldn't you get your younger brother a suit that fits?
It's a family affair over here. This is interesting.
Oh my god. This is going to be nuts. Again, also, the youngest brother, did they shop at the children's store? Because he can't even button it. Oh, and let's go to the court.
Maybe he put on a couple pounds, Mo. Cut him a little slack.
I'm trying to.
Ooh, we got movement. Court is in session, y'all. Here we go.
All right, Judge.
Probably nothing.
I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have
There
to
he
tell
is.
you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation.
Why is the verdict watch still counting?
If
They're
you
clearly not
happen
on.
to
They are
see
still on Verdict Watch, technically.
anything about the case, please disregard
Verdict Watch
it.
is lawn and crim.
Do
It's
talk
not
to
official.
anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all
4:30.
that if you can this weekend. We'll see you Monday morning ready to start up fresh. Thank you.
Well,
there we have it.
4:30, they said, no more. We're going home.
Yeah. Whereas I'd have stayed until 9.
Yeah. Well, they must feel that they're going nowhere. How long did you get in the other video?
We got through
let
the
me-
prosecution's opening statement. The defense just started.
Yes, and they're all
All right, well, I
related.
hope everyone has a good weekend with no work.
Yeah.
Thank you.
Just
Defense counsel is two brothers and a dad, which is kind of interesting.
yeah.
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 Well, let's see what my poll said. What did people think with the number of hours before a verdict? See you next week, 52%. 2 to 6 hours, 22%. 6 to 10 hours, 13%. And less than 2 hours, 12%. You were correct. We will see you next week. Mo, what are you doing over the weekend?
Let's see. Tomorrow at 3 p.m. we have Legal Shenanigans Theater with "Don't Yell for Me," Judge. Well, yeah, Your Honor. Don't yell at me, Your Honor, because it's Lori and this poor beleaguered judge getting into a shouting match.
I don't know what I'm doing, actually. I don't know if we're doing FNL
Could you
tonight. Haven't
look
heard anything.
less like a whiny little biatch?
Listen,
Oh,
the
I'm
Danish
so
flu is
huddled up.
serious, you guys.
Mo is more manly
Danish
than you
flu.
are.
The Danish flu is serious, y'all. This man gets me sick and then mocks me for being sick. This is ridiculous. I don't know if we're doing FNL tonight. Haven't heard anything. But tomorrow, Flux and I are going to be doing a stream. I don't know.
Oh,
what
I'll
time.
be with Flux too.
Tomorrow for the
Yep
250th Army birthday stream.
Yeah,
Yes.
I won't be. I don't get invited for anything.
Well, you weren't in the Army, so there's that.
I was in the Army.
No, you weren't.
You were
You
in
were
the
in some
Navy.
Danish Navy.
Mo
Jeez.
wasn't in the Army.
I failed out of basic. I still
She was in
attempted.
the Army. She didn't make it, but she went. She's got more Army. She's got more Army experience than you do, Baker.
I have flown in 4 Black Hawk helicopters.
4? Cute.
Yeah. Well, Mo, your number of Black Hawks. And we're not talking
None.
about the ice hockey team.
Neither with either, because I wouldn't have been impressed to be like, so what sport do you play? Is it curling? What is it you do?
Terrible. Terrible.
Terrible.
I've been in a couple Blackhawks.
Yeah.
Jumped out of them. Kicked indoors.
Not even part of the Coast Guard.
Medevaced in one. Had to bring a bad guy back on one in a medevac one time. That was different.
Well, I played. I was a momentum in or whatever you call it. I played injured in one of them. I had my bowels blown out.
Nice.
I had to lay there on the ground with rolls of sausage on my skin. That didn't feel good. And then we got airlifted to Tulsa Air Base, and they did all the, we're going to look at him. And I was just laying there thinking, there was a reason why I always was the light guy when we did school plays, because I'm a really bad actor. I don't want to do it. And then then they had to take an x-ray, and the asshole, he clicked it. And the head surgeon just flipped. Did you just take a real x-ray? Don't you know we don't have any protection? What? And I was just, well, now if I'm getting cancer, I'm going to sue the American Army.
Terrible.
No, I don't think so. But they strapped me in, and do you know how really? I wasn't as fat back then, but still in a Black Hawk where it's, I think they stack 4 gurneys on top of each other or something like that. There was
think it's
probably this
3,
much
but maybe.
room from my nose into the gurney above me. It was not, and that's the first time I've ever flew in a helicopter, and that motion is.
Did I ever
really
tell you
weird.
that story about when I got medevaced?
No.
No.
Oh, I busted my head open real bad, like real bad. And I got medevaced to Baghdad in a Black Hawk, and the guy, I don't remember if he was above me. I think he was the guy above me because they put you in the stretchers, right? And then they stack the stretchers on like the back wall of the helicopter. So it's like 3 or 4 or something. And the guy above me, the flight surgeon was breathing for him with one of those damn balloon pump things for the entire flight. So I'm laying there, right? My head's all busted open and it's all wrapped up, and I got a giant headache, all confused as shit. And for like an hour and a half, all I hear is the flight surgeon. Would not recommend, y'all. Would not recommend.
I have never been so happy I failed out of basic in my entire life.
It sucked. It sucked real bad.
But I'm glad you're okay.
You wouldn't sit here 25 years later and talk about how fun it was. And if you really try and remember how it was, you're thinking, people in some prisons had it better than we did. They don't have the pew-pews, but at least they could go somewhere. And they didn't accidentally find out 12 months after you arrived in the camp that there was actually an active minefield in the back of the camp. The area you used to do fire drills in.
Yikes.
Well, we had like a big area. We had a big, long, it was an old barracks for the Serbs. And then we had this back area where they just chucked cars in and stuff like that. And then when we turned over, I was team 10, 11, and when we turned over to team 12, 9, 10 turned over. Well, our turnover, they wanted us to do like a fire drill, and we went down there to show them, hey, look, we can shoot water at our major. Did that was fun. And then the new guys, engineers coming in to work on the flail, you know, the big mine flails.
Mine sweeper thing, yeah.
Oh,
yeah. Said, well, we have this parking lot in the back. You can just sweep that, and maybe 5 minutes after they started, goo.
Holy shit.
We did fire drills down there last week. Yeah.
Wow.
And the baker who had to come and take over for me, he was all John Rambo, big balls, didn't need anything. And one morning I came up, we had like a back room in the kitchen, came up, said, hey, you have to go to your security briefing. I don't need no security briefing. And you couldn't have timed it better. He just said security briefing, goo. And the rest of us had listened to that for 2 weeks. So we were like, oh, another one. And he was just, what the hell was that? Oh, that's the minefield in the back of the camp.
Maybe you should go to the
camp. And he was like, but goo. He said, yeah, it's really important with the security briefing. You get to learn about, we had these jumping vipers. They were assholes. They would like jump a meter in the air and just strike at you. You try to hit them with the truck. And what I was just sitting there, yeah, learn about the vipers and learn where them goo. And he's just, I'm going to the security briefing. Probably a good idea.
Good call.
We only had like a snake nest in the building where we had all our equipment because we didn't really use the basement. So they went down there because it was kind of kicking off. So they needed that space. Came into a room and they just saw this big ass MFer and it just jumped in the air and he just closed the door and he was like, nope. What the hell? We didn't really have snake repellent, so they chucked some CS gas in there. But they got them with a broomstick later. Yeah, they got it with a broomstick.
Yeah.
So, yeah. No, I didn't show him my Dutch oven. It was an Italian oven we had, and it was really bad.
Oh.
But that was fun. You guys, I'm not invited to anyone's anything over the weekend because I'm not fancy enough to join Flux. Flux hates me, I know.
I wasn't going to tell you, but yeah, she does. She totally hates you.
But congratulations to everyone who served in the Army.
250-year birthday.
250 years birthday. If you were Danish, you would be one of the younger companies, but good for you. 250 years ago, we lost to Sweden again. But I might do a show tomorrow saying thank you for all the gifts. I might just be in bed trying to get rid of this Rona. Sunday, I have a 90% deal done with Brit Happens, another YouTuber. but because it's Father's Day, time is a concept that we haven't figured out. So keep an eye out for that if and when it'll happen. But Brit happens. I have a half date with her, so it might happen Sunday. Again, I don't know what's going to happen over the weekend. I might try and watch some more of that Mini P case if I don't have anything else, because even though I'm tired as all hell, I normally stream. David Nelson, you're not on my channel, but I will get you banned on every channel.
Attaboy.
Look weekend. Does that mean lucky weekend? We'll be back Monday for more Verdict Watch, and we'll find some. We'll probably watch more of that Mini P River case. And I hope you have a wonderful weekend. Do all the things that you hate us talking about, and go out in the world and spread some donuts. Don't spread the Danish plague, is all I can say.
Don't do it. It's mean.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.